join audio.
So can I ask in advance which one is Mr. Delapian and which is Mr. Cardani?
Can you use your mute, please?
Thank you very much. Yes, I am Santiago Delle Piane. Good morning.
Good morning, I'm Andrea Cardani.
Okay, thank you.
Okay. All right, let's see everybody.
Mr. President, this is Gonzalo Zavallos. I'll be speaking for claimants today rather than Mr. Reisenfeld.
Okay, good. Mr. Zavallos, everybody accounted for a claimant side?
Yes, Mr. President.
Mr. Granet, anybody accounted for the respondent side?
Yes, Mr. President, we are ready to go.
Good. All right, then I open for what is it, day 7 of the hearing. Is there any point that you would like to raise? Wait a moment, we are wait date. I stand corrected. Day 8, if I do my math correctly, and today is the date about math included. So, all right. Any point of procedure, admin or household, Mr. Zavallos?
No, Mr. President, not from claimants.
Mr. Granet?
Nothing from respondents, so thank you.
We can start. All right. Mr. Zavallos, could you please introduce your expert witness?
Yes, Mr. President. We have today Mr. Santiago Delle Piane and Andrea Cardani from Berkeley Research Group, and they're ready to present to offer their direct testimony on damages for this matter.
Right. Okay. Let me go first. Is Mr. Delle Piane. Mr. Delle Piane, can you please state your full name for the record?
Santiago Delle Piane.
Mr. Delle Piane, you appear as an expert witness for the claimants. If any questions are clear to you, either because of language or for any other reason, please do seek a clarification. Because if you don't do so, the tribunal assumes you have understood the question. The answer corresponds to the question.
That's understood.
Now, Mr. Delle Piane, you will appreciate that testifying before a court and arbitral tribunal is a very serious matter. That connection, the tribunal expects you to give the declaration, the text of which will now appear on the screen.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Okay, thank you. Then I go to Mr. Cardani. Mr. Cardani, could you please state your full name for the record?
Yes, good morning. My name is Andrea Cardani of the Berkeley Research Group.
Okay, Mr. Cardani, you also appear as an expert witness for the claimants. Also for you, is it applicable that if there is a question unclear to you, either because of language or for any other reason, please do seek clarification, because if you don't do so, the tribunal assumes you have understood the question and that your answer responds to the question.
Understood.
Mr. Delle Piane, could you please also give the declaration, because testifying before a court or an arbitral tribunal is a very serious matter and the tribunal expects you to give this declaration.
Sure. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Then to the two of you, since we are on a virtual hearing, could you confirm that you're alone in the room, with the two of you together then? There's nobody else in the room? Mr. Delle Piane?
That is correct, Mr. President. We are alone in a room here in Washington at the law firm. There's no one else with us.
Mr. Cardani, same thing?
I confirm, yeah, that we are alone in the room.
Okay. Then, if at any time somebody enters in the room, please let us know, and then stop giving testimony.
Of course.
And then, may I invite you to scan the room, if possible?
Yes, I'm going to go ahead and do it. Bear with me for a second.
Okay, gentlemen, can you please switch off your iPhone or any mobile device you have?
They've been turned off already, sir.
Okay, thank you. Can you then go to the first joint report of 14 September 2020? And Mr. Della Piana, could you please go to page 74?
Yes,
And confirm for the record that the signature appearing above your name is your signature.
that is correct.
Mr. Cardani, can I ask you to do the same for your signature?
Yes, that is my signature.
Okay, then to the report of 20 July 2021, the second reply report. Can you please go to your page 84? Mr. Della Piana, can you confirm that the signature appearing above your name is your signature, please?
That is correct.
Mr. Cardani, can you please confirm that's your signature?
That is correct.
Thank you. Gentlemen, is there any correction, modification, or amendment you wish to make to either report?
Mr. President, there is one item of language of how we labeled one table in our report, table 1 in our second report, as a labeling issue, which we discovered in preparation for today. I plan to explain this, but I can tell you right now what the correct.
That's the table at page 24.
That's correct. Yes.
Good.
So the table, the first item in the table where it says but for value of the Mamacocha project,
yeah,
it should say, technically it should say damages in relation to the Mamacocha project, and then parenthetical but for plus actual costs. Our colleagues picked up on this in their first report, and we failed to correct our second report accordingly. Our colleagues for respondent, I mean, picked up on this, and they actually provided the correct illustration, but we failed to pick up and correct this in our second report. So it should say damages on the Mamacocha project, parenthesis, but for value plus actual costs.
Okay. Anything else that needs to be changed?
That's all. Thank you.
Thank you, gentlemen. Then, Mr. Bayo, are you still there?
Mr. President?
Yeah. Mr. Gane?
Yes, we have an issue to raise. I didn't want to interrupt the preliminaries, but we are mindful that the PO6 paragraph 23 contained rules as to the testimony of the damages experts. And this was included at claimant's request. And that section indicates that the damages experts should be logging into the virtual platform separately and refrain from interacting with the other testifying witness. Now, of course, we see that claimants, damages experts are together. Now, Mr. President, we've always insisted that we should be pragmatic. We are fine with proceeding in the way that they have set this up. But of course, we would expect that the same pragmatism would be applied in the case of Peru's damages experts.
Mr. Grenet, we're in absolute agreement on that, so that's not an issue for us. If you were happy for you to proceed in the same manner as we've set this up.
Okay, thank you. I appreciate that both parties are practical in this respect. Mr. Gane, your question, you raised also a very good question indirectly, is how many microphones do they have? Can you help me, Mr. Della Piana? Do you have a separate microphone or do you share a microphone, Mr. Cardani?
No, we share a camera and we share a microphone.
All right, okay. All right, then, gentlemen, when you get at the cross, I don't know, Mr. Cardani, are you conducting the cross?
Pardon?
No, Mr. President, my colleague, Ms. Amy Endicott will.
Okay, Ms. Endicott. All right, so she has to identify whom she will address the question to. Huh? Good morning, Mr. Endicott.
Understood, Mr. President.
So you're aware. So when we get to the cross, still 45 minutes to go. Then can you clearly identify who you would like to ask the question?
Sorry, Alberian. Excuse me, I'm probably wrong. But we're not applying the principle that the question is made to the leader and the leader decides who answers.
You know, I'm a little bit afraid that that's true, but I'm a little bit afraid that that becomes then a joint song, and I would like to avoid the overlap. So it's more, if we can, in the spirit of practicality or being practical, maybe you can address it first to the leader. But I wonder who's the leader, Mr. Della Piana. You are supposed to be the leader.
Well, I guess I will be acting in that capacity, and we have divided up the topics in a manner that we will not plan to address any question twice or anything of that sort. And I will pass on to my colleague the questions that he has been assigned to, or the topics, generally speaking. We'll pursue lines of questioning and not be ping-ponging between each other.
Okay, and let's see how it goes. If it's a difficulty for you in the cross-examination, in handling logistics, let me know, and then we make further rules.
Thank you, Mr. President.
Yeah, you have it.
Mr. President, but one point of clarification on this topic, then the rule stated in paragraph 23 that only one expert can respond to each question. That rule remains, correct?
Remains, yes, exactly.
Okay,
But I would like to make it streamline it in the question in practice, that you know to whom you should address it. And maybe that comes as well. It's not me who can answer this question, but the other candidate answer this question. But let's see how it goes, because we already see an event. I assume during the direct and the presentation that who is dealing with which subject matter. Yeah.
Thank you.
Okay. Shall we go, Mr. Bios?
Yes, Mr. President.
The directives for you now.
So,
We are now sharing a presentation. Let me just organize our screen so we can see the presentation as well as you, gentlemen. 1 second, please. Okay, can I confirm that you can see the presentation in full screen mode?
Yeah, okay.
Okay, excellent. Thank you, Mr. President, members of the tribunal. Good morning.
Before you start, Mr. Cardani, since we're dealing with numbers as well today, I was correct originally that it's day 7, not day 8 for the transcript. So sorry for interrupting, but I want to have this cleared out of the way immediately.
Okay.
Right? Okay. Then, Mr. Della Piana, you may start now.
Thank you very much, sir. Okay, our presentation contains 3 core sections. I will be covering the first one. My colleague will cover sections 2 and 3, and there are a few remaining slides that present supporting materials in case there are specific questions on the backup to what we have put together for today. Turning to the affirmative assessment of the fair market value, I would like to first remind you that we pursued 2 approaches to determining damages in this case. One based on the fair market value standard, which includes 4 categories of damages, 4 items, which are depicted in a graphical timeline format in this slide. And I will come back to this in much more detail. Separately, we have presented an investment value calculation, that is a reliance approach to damages based on the investments made, updated or capitalized at a risk-adjusted rate. My colleague will be addressing that. Turning to the fair market value calculation, sir, we have assessed damages as of the date of our second report, which is the latest figures presented on the record by us, $45.62 million. This is comprised of $25 million, as you can see on screen, of fair market value, but for respondents' actions, net of the actual value of 0. Additionally, $6.68 million of costs that were incurred after the date of valuation, but which are already deducted in the fair market value calculation. In other words, the fair market valuation, as it does through a discounted cash flow model, takes revenues and subtracts certain costs. And some of those costs were spent anyway, so they're not just theoretical. So they need to be added back here to avoid a double dipping on the damages, so to speak. That complete 25 plus 668 is the complete amount of damages pursuant to the table that I just corrected earlier. Table 1 from our second report, that is. A third category is the pre-award interest, which serves to take all those damages which are expressed as of the date of valuation of March 14, 2017 to the date of our second report. And finally, there are $2.68 million in additional expenses that were incurred by claimants to wind down. These are mostly legal and operational expenses to wind down their business and associated with the litigation. So, pardon me, I'm looking at my pages here on the screen. I'm not sure why I'm looking at the pages. I have the screen. In this case, we have detailed information on what is effectively a pre-construction stage project, but we have very detailed information that allows for a reliable calculation via discounted cash flow analysis, something our colleagues from Versailles agree with. This includes, in order to estimate revenues, the RER contract itself, which presents us with the volumes, the majority of the volumes to be sold, and the prices at which those volumes would be sold, as well as an hydrology study by the firm Poiri and an independent study by BA Energy Solutions that forecasted electricity prices via a sophisticated dispatch modeling exercise. For the costs, we have a number of third-party studies, which I'm not going to read through all of them, but including the GZZ proposals and other feasibility studies, as well as for the interest, we're using the DEG term sheet, that is the financial institution that was working with claimants to finance the construction of the project. Finally, with all this information, we can calculate free cash flows to equity, net of debt payments to the lenders, and that needs to be all discounted to present value at the date of valuation of 2017, using a discount rate, a cost of equity in this case, because these are free cash flows to equity, and to consider the risks that were not otherwise accounted for in those cash flow items that I described. For that, we use the standard approach, standard and proven capital asset pricing model, and public sources of market data. Regarding volumes and prices, we know from the RER contract that in the first 20 years, about 96%, more than 96% of the energy will be sold pursuant to this RER contract. We also know that, pardon me, that the price at which all that energy will be sold. For the remainder of the energy not sold via the RER contract, we use the spot price projected by BA Energy Solutions in their dispatch model exercise. For the following 20 years after the expiration of the RER contract, we use the BA Energy Solutions forecast for energy prices in Peru. And now we have to switch from the spot price to the monomic price, which includes the spot price plus a capacity charge. This is all standard and once again unchallenged by respondents' experts. To fund the construction of this project, you see on screen that there were studies that allow us to know exactly how much, with great degree of certainty, how much this project would cost. That is the capital expenditures or CapEx. And we also know what it would cost to operate the project in terms of OpEx or operating expenses. Now, to fund this, we need to understand, because it's a very substantial amount of money, how a company actually undertakes such a choppy, such an irregular pattern where you have not a project that actually has steady cash flows of investments and costs year by year by year, but one that has a very particular pattern, as you can see on screen, in which in the first 3 years you have a huge amount of expenditures, and then it's time to recover. So I'm going to take a slight detour here and explain to you something you perhaps already know, but just for the sake of clarity, in this case, it's important to understand how these projects get funded. And that is through a great amount of debt or leverage. For that, let me use an example. If an equity investor considers a $100 investment that has a $6 payoff, And let's assume for a moment that it uses no leverage. The $100 investment is all equity. And let's assume that, let's see, in one period example, this would mean that it has a 6% return, $6 over the $100 contributed, right? And let's assume now that that investor's hurdle rate or minimum rate of return is 8%. Well, in that case, that investor would not invest because 6% is lower than 8%. It's very simple, right? Now, if it actually uses debt or leverage, let's assume in an 80-20 basis and now puts $20 in equity, $80 in debt, what it will find is that the same project return needs to go to both lenders and equity holders. And the lenders would receive, assuming a 5% interest rate in this example, purely for illustration purposes, would receive 5% of the $80 they put, or $4. And the equity investor would receive only $2. And you might say, well, it's even worse now, it only received $2, but obviously that's not so, because it receives $2 on the basis of having contributed only 20 this time. It still can pursue the project, it's still able to pursue this going forward via leverage, via the bank financing it, but it receives a 10% return. So he would invest in this example. Now, this is important. This is why people buy real estate on a leverage basis, not just because they can't always afford it to put it all down, but also because if the real estate appreciates, you keep the difference, you keep the appreciated value. But you would run a huge risk, don't you? Which is that if it depreciates, then you still owe the bank a huge amount of money in a mortgage or in a loan, right? However, in this case, the lenders are protected by the PPA. And that's fundamental to these types of projects and project finance, is understanding that lenders look for the assurance of a power purchase agreement, such as the RER contract, in order to use that as a sort of collateral against which they're loaning their money. With this preliminary, you can see on slide 10 here on screen what the pattern of withdrawals, borrowings, and then repayments is. You see the first 3 years of borrowing cumulatively, and then returning and repaying the loan up to 2033 when the loan would be fully repaid. This is the pattern of financing that we follow in our model. We use the interest rates presented by DEG, 7.36 during construction, 7.06 after construction. These compare very highly to the market cost of debt for a project of this sort in Peru at 4.28%. We didn't use the 4.28% because this was, in fact, a pre-construction project. Then these were the rates that were quoted by DEG. So we used the 736 and the 706, which obviously are a huge cost to the project, which is deducted in our discounted cash flow model. This has one other effect, which is in the cost of equity calculation. And obviously, if you have any questions on this, we're happy to answer them. The cost of equity calculation also moves in tandem with the leverage. This doesn't happen in all projects, but with one that has such a huge amount of borrowing in the beginning and so little at the end, the risk to the equity holder is not the same year by year. It's different because the equity holder is first concerned with repaying the loan, and there are not that many amounts in cash flows that are available to distribute to equity holders. Therefore, when the loans are high, the loan balances are high, the risk to the equity holder is higher. When the loans are repaid, the risk to the equity holder is lower. And that's what you see here. So there's a moving curve of cost of equity. And once again, you'll see from my colleague's explanation in a moment, our colleagues from Versailles agree with this pattern, disagree with the inputs to our calculation. So to summarize on a big picture basis, the risks that are typically considered in a project at a pre-construction status, cost overruns, delays in construction, financing. These are accounted for in CapEx contingencies, timeline contingencies, and the types of rates, the level of rates that we've assumed in the model. Volumes and prices are protected by the RER contract. Operating costs are also protected by inflation clauses, inflation protection clauses in the RER contract. And finally, country risk, an important category of risk that investors are always concerned about, is accounted for somewhat protected by the RER contract, but is accounted for in the discount rate with a full amount of country risk premium that we have applied for Peru, with no downward adjustment, despite the fact that there's fiscal stability agreement clauses. So this gives us the $25 million fair market value calculation. That is the present value of future expected cash flows of the project at the date of valuation looking forward, discounted to March 2017. And in this case, we have a very unique situation, which is that 1 month prior to the date of valuation, we have a contemporaneous offer for an investor, a sophisticated investor who had been conducting due diligence to participate in this project. And what this investor said was that they would recognize 7.63 million of the investments made by claimant up to that point in time. In exchange for a 30% share, they would contribute, the rest of the CapEx, the majority of the rest of the CapEx, and actually simply by taking the 30% associated with the 7.63 million, you can derive an implied project value. Basically, Interject said, recognize the 7.63 equated to 30% of the project value. So the 100% of that project value is 25.43. Additionally, Interject recognized a development fee for a total project value of 26.93 for 100% of the equity. This is a very unique situation, as I explained before, and one that our colleagues from Versailles have actually misused, or used incorrectly, I should say. Let me explain how. They say it doesn't actually matter what Interject's implied valuation was. What they say is Interject hadn't yet put the money. What matters is there's a piggy bank example they provide, and so this should be treated as a piggy bank or a checking account in which the only value comes not from the cash flow generating ability that Interject was very aware of, but from the status of the bank accounts, basically, the balances up to that date. That is how you value a piggy bank or a checking account, not how you value an infrastructure project in a pre-construction status that has an ability to determine cash flows going forward, as they recognize. It disregards the intrinsic value of the underlying asset, which is the RER contract. And it ignores the $17.8 million in project commitments that Interject makes, which I'll come back to in a second. Finally, they talk about a pre and post money framework. This pre and post money framework you're going to hear about, or you've read about, is, according to literature presented by them, actually, in one of their papers, it's as the literature says, is for early stage companies that are comprised of often little more than an entrepreneur with an idea. These are basically the pre and post money valuations are used when you have two friends in a garage with an idea, and one of them put $100,000, the other one still hasn't. So the question is, if I put another $100,000, how do we split the business? Well, 50-50. Until you do, we split it 100 and 0 because you've put nothing. But those two entrepreneurs with an idea in a garage, in their mother's garage, don't have the ability to determine the cash flows or the value of the underlying asset because all they have is just an idea. Versailles presents this alleged benchmarking exercise, and I will take a moment to walk you through why literally every single bar in this chart is actually misrepresented, including ours. First, the February 2017 offer of Interject. As I just explained, that is not correct. It is not a piggy bank. Interject recognized that $7.63 million corresponded to 30%, not to 100% of the equity. So that doesn't apply. It's $26.93 million, as you see on screen. The $7.23 million, the Interject model NPV, is based on a hurdle rate of 8%. It is not a cost of equity or a discount rate. It is a hurdle rate, and it's explicitly said so. It cannot be used for valuation purposes. We explained this at length in our second report. Finally, well, not finally, the 4 offers in 2018, I'm going to come back to these offers in a minute because these are extremely important and extremely mischaracterized in this chart. they do not reflect the additional capex. They do not reflect the value that Interject sees in the project. I will explain this in a moment. They're not assessments of fair market value. Finally, Versailles says that their assessment of fair market value is $7.52 million. That is actually not entirely true. $7.52 million includes actual costs, both in our bar and their bar. But it is, the $7.52 million is conveniently near the other numbers, but it's actually not correct. The 7.52 is not such. The fair market valuation, which is the present value of future cash flows from that point forward of Versailles, is $3.4 million, not 7.5. And ours is not 3175, it's 2507. You see why I wanted to make that clarification about our report and table 1. Let me turn to these offers that happened in 2018. There were 4 offers, 2 by Interject and 2 by the firm Glenfarne. I'm taking just one here from November 2018. And now I ask you to look at this from the point of view of the buyer. Okay, we've been looking at fair market value in general, but from the point of view of the buyer. In November 2018, Interject says, I will pay you, Latam Hydro, $7.2 million for development costs. $800,000 is goodwill for a total of $8 million. And Interject or Glenfarne know that from that point on, almost immediately, they need to disburse at least $17.8 million, $17.8 million of CapEx in equity, on top of what would come from debt. They know they need to disperse $17.8 million in equity almost immediately. So if you are the buyer, if you're Interject or Glenfarne, do you really believe this project is worth $8 million? No, if you did, you would be crazy, literally crazy, because you'd be paying $8 million for something that you'd be paying, $25 million, that is the 8 plus the 17.8 that you're about to disperse for something you think is worth just 8. That is not what Versailles has done, not the correct way of interpreting the Interject or Glenfarne offers. The Interject and Glenfarne offers, what they do, and you can see in this slide 17, is recognize an amount of initial payment to Latam Hydro, and they recognize an amount they need to invest almost immediately. So the implied value that they see in this project cannot be $1 less than these figures you see here, 24.8, 25.8, 25, 25. Basically $25 million is the minimum they saw as prospective value in this asset, discounted to present value. At the greenfield, I should say, advanced greenfield or pre-construction stage. So this is them buying at that time, considering the fact that they obviously want to keep some upside. They would like to extract the full amount of the intrinsic value of this asset. And for that, they want to pay some amount, and they would like to, and that is comprised of the amount they disperse to Latam Hydro, plus the amount they will disperse to the CapEx in the project. But that means that the value of the project itself cannot be any less than that. Now this, you see on screen, is the correct benchmarking exercise with the Interject, Glenfarne offers, and the correct numbers for both Versailles and for us. In summary, and this is probably the most important part of this presentation, and then we'll turn to some of the details. In summary, in February 2017, Interject valued the Mamacocha project at $26.93 million, no less via that offer of February 2017. In 2018, the offers confirmed that from the buyer's point of view, the value implied in the project couldn't be less than approximately $25 million. And this recognizes already the advanced greenfield or pre-construction stage of the project. Our valuation considers all this and the associated risks, and happens to be very near those valuations by these sophisticated potential buyers. It also confirms that our discount rate must be reasonable, because this project is extremely sensitive to the discount rate, extremely sensitive. I talked about fair market value enough. $6.68 million, I mentioned before, is the amount of actual costs that were disbursed by claimants that are already deducted in the DCF and therefore need to be added back. $11.19 million of pre-award interest, and $2.68 million of additional expenses takes us to the total damages under fair market value standard of 45.62. My colleague will continue with responding to Versant. Thank you.
Thank you. Let's now move on to our responses to Versant incorrect fair market valuation. Now here in this slide, you see a reconciliation between Versant incorrect valuation of only $3.4 million with our valuation of $25.07 million as of the DOV. As you can see from this slide, the majority of the difference, as my colleague just mentioned, is driven by the discount rate for a total of $15.9 million. Then there are 4 additional differences that reflect differences in expert opinion within the cash flows. But let's jump into the main component, which is the discount rate or cost of equity. Now, these slides here, the graph shows you the difference between Versant and BRG cost of equity over time. Now, this difference, as I just said, generates a large difference in total fair market value. What are the 3 main determinants and areas of disagreement between us and Versant? They are the risk-free rate, the market risk premium, and the unlevered beta that are reported here on the table on the left-hand side of this slide. So let's just dive into each individual element. The risk-free rate, the first element. Now, in order to determine the appropriate risk-free rate to calculate the cost of equity according to the capital asset pricing model, we use the recent history of yields of the 10-year treasury bond in the 12 months prior to the date of valuation. In this way, by calculating an average metric, we effectively smoothens out daily fluctuation of the index. So our estimate of the risk-free rate and ergo of the valuation is very robust. On the other hand, Versant took the second highest yield in the 2-year period prior to the date of valuation, which is 2.6%. Of course, this selection entirely biased the calculation of the discount rate. Now, Versant framework is fundamentally incorrect and is inconsistent actually with the framework that a negotiating willing buyer and willing seller would take to value an equity stake or value in general the Mamacocha project, right? So if you just change the valuation date a little bit and move it from, say, March 14, 2017 back to September 14, 2016, the risk-free rate would be significantly lower, as you can see from this graph, and therefore the valuation would be significantly higher. So this methodology that they use is fundamentally inconsistent and inapplicable to determine the fair market value of a project like the Mamacocha project. Now, in addition to this, I would like to mention also that our estimate of about 2% point of risk-free rate is actually consistent with the downward trend in US Treasury yield over the period from 2000 to 2019, and is consistent and supported with the analysis and research of economists at the Federal Reserve Bank of San Francisco in December 2016, which say, quote, the interest rate are at a low new normal, okay? So this further corroborates and validates our choice of our risk-free rate. Now let's move on to the following component. Second component that determines the difference in our cost of equity analysis, the market risk premium. Now the market risk premium is a measure of the systematic risk of the market portfolio. Now in order to estimate it, we use the geometric average return between 1928 and 2016 of the US market, which is a widely accepted standard approach used by valuation practitioner and academic, and obtain a rate of 4.62%, as you can see here. On the other hand, Versant selects an estimate from Duff and Phelps in 2017 of 5.5%. Now, in our second report, we performed a benchmarking analysis and conducted a thorough survey considering a number of alternative estimation of equity risk premium presented by academic and practitioner in the period leading up to the date of valuation, as you can see here with these dark blue bars. Now, when you calculate the median or the midpoint of all of these surveys, the median is 4.62%, which actually correspond to the metric we select in our analysis. On the other hand, as you can see here, Versant's estimate tend to overstate the market risk premium as compared to the consensus in the industry. Now, let me also comment on an analysis that Versant introduced in their second report, which is entirely flawed. Essentially, to rebut to our survey, they calculate the total return on equity using a subset of the surveys that we used in our prior slide. This analysis is flawed for at least 4 reasons. First of all, it removes and excludes the survey presented by Bank of America, which indicates a risk premium of 4.6%. Second, in at least 2 instances, they duplicate the same survey in their analysis. Third, and most importantly, for certain element, and you can see them down here at the bottom bars, for the risk-free rate, they actually use the risk-free rate average over a period of up to 116 years. This analysis is simply untenable and should be rejected. Now, let's move on to the third and last component that determines the difference between our discount rate or cost of equity and Versant cost of equity, which is the beta. Now, the beta, in a nutshell, represents the exposure of a company or a project with respect to market risk, where the market risk is defined as the risk of the market portfolio, which is the US market or the Standard & Poor's 500, okay? I want to also emphasize one point and underscore that the Mamacocha project, by virtue of the RER contract and the sovereign warranties set forth herein, is insulated for a large number of market risk factors, including energy prices, energy volumes, costs, and foreign exchange. Furthermore, by virtue of the nature of the project, the Mamacocha project had priority energy dispatched in electricity market in Peru during the RER for any excess energy and after the RER for the entirety of the energy produced. So in taking that into consideration, one would expect the beta or the exposure of the Mamacocha project to market risk to be low. So in order to estimate our beta, as I just say, we use a very standard methodology and we calculate the beta with respect to the market portfolio, the Standard & Poor's 500. To do so, we selected as the representative industry, the US power sector. By doing so, we obtain a levered beta of 0.46%. Now here it's very important to note that since the components of this US power sector index are companies that sell in the spot market, the beta would tend to overstate and not understate the exposure to market risks. Now let's look at what Versant has done. And what they did is incorrect and in stark contrast with academic literature on valuation and standard practice. They did calculate the beta using a selection of companies in local indices such as Brazil. Now, if you look at the literature record, and here we just put 2 examples, this is absolutely something that you should not do. Kohler, a reputable valuation practitioner, say you should not, however, use a local market index to measure the market-wide systematic risk. Professor Damodaran says the betas of all Brazilian companies, some of which Versant uses, are unreliable. Okay, so this is one important source of bias and unreliability of Versant calculation. Second, Versant applies this beta calculated on local indices with the market equity risk premium calculated on the US market. So there is a fundamental inconsistency in these two metrics. Effectively, what they do is not a methodology supported by the literature, by valuation practitioners, and it should be entirely rejected for the purpose of calculating fair market value. Now, I want to also talk about and respond to a critique raised by Versant with respect to the overall reliability of our cost of equity. Now, what Versant does is apples to oranges comparison. Effectively, what they say is, if you look at BRG unlevered cost of equity, which is 5.79%, and you compare it with the interest rate on the DG loan on the Mamacocha project, which is 7.10% on average, BRG has unreliable results that do not meet corporate finance principle. Well, the problem of this comparison, as I said, is that compares apples and oranges. Now let's do the comparison correctly. So in order to do the comparison, you should look at the cost of equity of the Mamacocha project during the very period of loan repayment when the actual DG loan is in place, which is 7.42%, and compare it with the interest rate on the DG loan. And as you can see from this comparison, on the left-hand side, during the construction and operation and debt repayment period of the Mamacocha project, the cost of equity is higher than the interest rate. Second, just as a reference, this cost of equity, the 7.42%, is significantly higher than the market cost of debt for companies operating in the power generation sector in Peru. Therefore, our analysis of the cost of equity does fully meet corporate finance principle, and Versant critiques are completely unfounded and flawed. So this concludes our parenthesis on the cost of equity, right? The major difference. By the way, one note about it. The three different adjustments, effectively, each of them have 1/3 of the effect of correcting the 15.8 damages that you saw on slide 21, okay? So risk-free, market risk premium, and beta have more or less kind of an equivalent effect to each other. But now let's move on to respond to the other critique that Versant has with respect to our cash flow analysis. The first one is the inclusion or exclusion of the performance bond. Now, I'm gonna go very quickly on those, and there are a few backup slides if the tribunal has any question later. So for the interest of time, the performance bond, in our opinion, does have to be considered in the cash flow calculation, because claimants cannot simply assume that the bond will be returned. So the two performance bonds, one on the ARB contract and one on the transmission line, must be part of our discounted cash flow analysis to determine fair market value. Second, Versant raised issue with respect to the ARB contract sale and claim for a reduction in the volume of energy produced. We think that the calculations and the critique presented by Versant are entirely speculative and inconsistent with the industry standard, as they effectively assume a particular number of dry years and a particular magnitude of those dry years over the life of the ARB contract. The adjustment is simply speculative, and if you read the record, it's also in stark contrast with the testimony of Mr. Bartrina and the approach used by Interject, which, as my colleague just explained, was a willing buyer of the Mamacocha project. Third, the timing of the construction cost. Now, in our method, in our way of determining the cash flow analysis, we assume an even distribution of the capital expenditures in the 30-month period of construction, evenly distributed. This is consistent very much with the methodology and the views of prospective investors such as Interject. On the other hand, Versant uses a methodology included in the Hatch report, which was not an investor and typically has inputs that represent a worst case scenario. So we reject entirely Versant critique and we stand behind our approach. Last, the access road contingency. Now, in our analysis, we use a contingency amount based on the Poirier report. Versant disagrees, stating that we should use contingencies included in the Hatch report. Now, this contingency is extremely high and again represents a worst case scenario. The contingency is about 55%. Now, using this contingency or a worst case scenario contingency is inconsistent with the underpinning of the fair market value standard used by a willing buyer and a willing seller. And so we reject also these critiques entirely. Now, I want to turn page, and this is, I know that this is a lot of information. Now, I want to move to the next chapter, which is actually relating to the actual cost that were incurred by claimant after the date of valuation for the development of the Mamacocha project. And very briefly, I want to emphasize the lack of basis and arbitrariness of Versant's exclusion of 40% of actual cost. Effectively, Versant present an approach that categorize in an arbitrary way the budget and actual cost of the project, and inaccurately remove about 40% of this cost. Thereby, their assessment of total damages is incorrect. In addition, the second error that they incur is that they ignore unanticipated expenses, including administrative and legal costs, that the project did incur after the date of valuation due to the very measured issue. So effectively, they severely understate damages also for this reason. And here we included a passage of Mr. Sealand witness statement that explained this point very clearly. Now let's move on to, I would say, the last key component of damages, the pre-award interest. In our analysis, we determine a pre-award interest that meets the principle of full reparation. In order to do so, we use the project's interest rate, that is the DG, the interest rate on the DG loan, which provide effectively a reference interest rate or a minimum reference interest rate for a project with the same risk profile as the Mamacocha project. So this is what you see on the left side in blue. On the right-hand side, you see Versant three alternative interest rate used for pre-award interest. Now, none of these interest rates have any bearing or any relationship with the project, so they cannot be used to accurately estimate damages and full reparation of claimant. And in particular, one of them is significant, right? They use, as one of the alternative rate, the US Treasury yield. It's clear that only the US Treasury can borrow at that rate, which is less than 1/3 than a proper pre-award interest rate that we use. Okay, so this part concludes the review of Versant critiques to our model and our rebuttal of all of the details. Now I'm gonna move on to our alternative valuation approach. Now, we were instructed by counsel for claimants to also calculate damages under an investment value framework. The calculation is effectively based on the total amount of investment that the...
Mr. Cardani, may I ask you a question on the previous slide?
Absolutely.
Interest. Is the interest compounded as so much quarterly, yes, yearly?
Semi-annually. Our calculation compound the interest semi-annually consistent with the terms of the DG loan.
Okay, thank you.
Thank you for your questions. So let me unless you have any other question, I'm going to continue with the investment value approach. Now, going back to this, the calculation of the investment value approach considers all of the investments and costs effectively incurred by claimants in the period from 2011, when they started working on the Mamacocha project, up to 2020, totaling $24.27 million. Then, in order to calculate damages and meet the principle of full reparation, we applied to each individual annual investment a rate of return equal to the cost of equity of the Mamacocha project, to reflect the opportunity that was actually lost by claimant in connection with these investments. Okay, so basically by applying this return, we arrive at total damages of $36.29 million. And then there is a final step. We were instructed by counsel for claimants, as we did effectively for our fair market value analysis based on the discounted cash flow model, to also include additional expenses relating to the winding down of the project and legal expenses incurred by claimants, which are approximately $2.68 million. So the total damages under the investment value framework are $38.97 million. And this is kind of the baseline or the floor of damages in this case. Now, moving on to some of the critiques that Versant has raised with respect to this analysis, we want to provide a few brief responses. So the first one, it relates to Versant's critique that the data we use, the accounted record, is unreliable, and therefore the calculation of our investment value approach is unreliable. Well, based on the explanation provided by Mr. Sillen, with respect to the accounting record, this accounting record have been faithfully reflect the cost figures for the Mamacocha project and the upstream project, and they've been reconciled against documental evidence. So they are reliable. Second, Versant would like you to exclude certain investment related to upstream projects. We disagree, because the expenses related to upstream project were actually related to a project that was incremental to the Mamacocha project. So they should be included because claimants lost these monies due to respondents' measure. Third, performance bond, and the reasons are the same for us to include the performance bond. So I'm not going to repeat what I described earlier with respect to the discounted cash flow method. And four, the capitalization rate. As I just said, in order to calculate full compensation for the claimant for having invested this money into a project that was terminated by the measure enacted by the government, you have to consider an appropriate rate of return that reflects the return of a project, the very much per Mamacocha project, the very return of the Mamacocha project during the period. So the use of the cost of equity is the appropriate rate to perform these calculations. Now, I'm going to bring all of this to an end, and I'm going to leave you with this summary slide that compares or presents the results of both our methodologies.
Before you do that, Mr. Cardani, first of all, can you go back one slide, please? Again, one slide.
Yes, this one. Is this it?
And all expenses incurred. So the total. So you said 24.7 million. You see total normal investments. If you go to page 68 of your first report, you have a table 8.
Yeah.
Does that correspond to cash outlays?
Yes.
So your amount increased from 23.9 to 24.2, 24.3.
Yes, I think that. I apologize. I didn't mean to interrupt.
Can you explain the difference?
I would need to go back and look exactly at the backup, but I believe that between the first and the second report, there was an additional reconciliation performed to make sure that any criticism raised by Versailles was addressed. And actually, we found out, or Mr. Sillen in reality found out that the costs were slightly higher, right? They went from 23.9 million up to 24.2 million.
Okay, and now an elementary question. The 30% equity contribution, that was some 7.3. These are two different notions, the cash outlays and the capital expenses versus the equity contribution.
Well, there is a significant difference between the two numbers. Okay, there's just in a very general term, the $7.63 million correspond to the investment performed by claimants and recognized by Interject in their offer, and correspond to cost incurred up to approximately the time in which the two parties were negotiating in February 2017. In reality, the total amount of investments undertaken by claimants was more at that date. It was about $12 million. Okay, so Interject only recognized a portion. This analysis then, so that's one comment I have. Second, the second difference between that number, that 7.63 number that actually goes up to $12 million, correspond to all of the costs, investments in additional feasibility studies and development work that the Mamacocha project undertook after the date of valuation in the hope of continuing the development of the project. So their cost expensed for the most part up to 2018 and include also costs relating to the maintenance of the performance bond up to date, effectively. So this is why you go up to $24 million, because you actually consider all of the investments, all of the costs incurred by claimants into the project.
So if I understand you correctly, so at the time of the Interject's offer, they said they valued at 7.3, but you said no, the actual costs were 12.
That's correct.
Then you add the performance bond, 5 million, you arrive at 17, correct?
Correct.
And then you, for some reason, you get from 17 to 24.
Yes.
And how can you explain that? Between 2018?
So, this is related mostly to additional costs related to the development of the project, including additional studies performed by claimant in the period 2017 and 2018. And include, of course, also the cost of running the project, right? Administrative costs that were incurred by Latam Hydro during that period. They are all project-related costs, specific to the development of the Mamacocha project.
Okay, all right. I leave it there because I assume that will be also explored on cross-examination. Okay, thank you, Mr. Cardani.
Absolutely, thank you. So, and I'm just gonna put back this slide, which effectively concludes our presentation.
Ms. Endicott, now you can hear me. I see. Please proceed with the cross-examination.
Thank you, Mr. President, members of the tribunal. Hello, Mr. Delapiane and Mr. Cardani. My name is Amy Endicott and I represent Peru in this matter. I'll be asking you some questions today. As you've probably heard throughout the course of the hearing, we have a court reporter who's assisting us, so it will be important to speak slowly and clearly. Will also be important to let me complete my question before you begin to give your answer. And we'll try our best today to ensure that we get a clean record. Sound good?
Sounds great.
Sounds good. Thank you.
Should have addressed that question, I suppose. All right. So starting first with Signora Del Piane, did you attend claimant's opening statement?
I did not.
Have you reviewed the transcripts from that day?
I looked at the presentation and I had a conversation with my colleagues about it. I don't know that I can say that I reviewed the transcript in that detail.
Okay, for Mr. Cardani, did you attend claimant's opening presentation?
Yes.
And have you also further reviewed the transcripts from that presentation?
No, I had some follow-up discussion with counsel for claimants.
I'm certainly not asking about your discussions with counsel, just to be clear, but thank you. Okay, so Mr. Della Piane, then would you agree with counsel for claimants that the value of where the value of an investment has been destroyed, the valuation of damages should reflect the fair market value of that investment?
I understand that to be the standard under which I do a great vast majority of my work. I don't think I have an issue of agreement or disagreement. I think that's pursuant to the case law or the treaty that is invoked here.
Okay. Now, in paragraph 90 of your first report, you actually explain, Mr. Della Piane, that fair market value represents a standard measure of value based on a hypothetical contract between two well-informed parties in which neither the buyer nor the seller is participating under coercion. So you would agree then that it's important that both the buyer and seller are well informed of the risks of the project, right?
Sure.
You also mentioned that neither party must be participating under what you call coercion, right?
That's right.
Okay. And by coercion, I suppose you mean that neither party is being induced to complete the transaction by threat or by force, right?
Well, I think it's slightly broader than that. Any distress sale would also qualify as being excluded from the fair market value standard. I'm not sure we agree on the language of coercion. There's different definitions of FMV, but distress would be an important departure from the fair market value standard.
Okay. And in preparing your evaluation, you've attempted to estimate the fair market value of the Mamacocha project as of the 14th of March, 2017, right?
Correct.
And you chose that date, presumably, because you didn't believe that at that time claimants were operating under coercion to sell their equity stake, right?
No, we didn't choose the date.
So you were instructed to choose that date by counsel?
We were instructed to use that date by counsel.
Okay. And it's your understanding that as of that date, there was no effect from what's alleged as the breaches of the TPA or RER contract here?
Our understanding is that as of that time, we have enough information to perform a clean valuation of the project under the fair market value standard.
And so by clean valuation, you mean before that valuation was affected by a breach? Is that correct?
The main breaches that are central to the claim, as I understand it, take place from that day onwards. But we're treading dangerously close to legal opinion of what are exactly the breaches. We are quantifying this as of March 14, 2017, clean of the measures that are stipulated in our reports, I think paragraphs 3 and 4 of our first report.
Okay, thank you. Now you estimate the fair market value at 14th March 2017 using a discounted cash flow or DCF model, right?
Correct.
And that approach is actually endorsed by Professor Damodaran, right?
The good and the bad about Professor Damodaran is that he writes a lot of stuff. So I'm sure he's endorsed, and I know for a fact he endorses the use of DCF, but we should be careful to see in what context you refer to his endorsement of this.
Did you review your reports in preparation for the hearing today, Mr. Delapiane?
My report?
Mm-hmm.
Yes, I did.
Both of them?
Yes.
Okay, so you're aware in your first report, PDF page 43 at paragraph 96, you mentioned that Professor Damodaran actually endorses the DCF approach for fair market value, right?
Let's see.
And if helpful, my colleague, Ms. Giraldo, can put that up on the screen for you.
Yes, he did. Yes, he does. Like I said before, I know for a fact he endorses the use of fair market value. I was just pointing out the importance to look at Damodaran's papers in their context because of how much he produces. Very prolific.
Okay, I would appreciate if you could just stick to answering my question.
Pardon me.
All right. So, in fact, you actually cite to no less than 7 publications by Professor Damodaran in your report, right?
I'll take your word for the number. I have to check.
All right. And who is Professor Damodaran?
He's a scholar, professor from NYU at the, I believe at the Stern School of Business. He has become very popular for both his, how didactic he might be, and as well for how much he publishes in terms of compiling data and making it public. He publishes his drafts, he publishes all his writings, musings, and a lot of data. So he becomes a bit of a repository for people like us to obtain accessible data.
Now, you would only cite data that you considered reliable, right, Mr. Delapiane?
That's right.
Is it fair to say then that Professor Damodaran is a leading financial valuation scholar?
He's a well-cited financial scholar, yeah.
So you'd agree that he's a leading financial valuation scholar?
Yeah, I'm not sure what the rankings are. I would say he's very well-regarded and well-cited. Leading means ranking, and I don't think there's such a thing.
Okay, I'm just confused that you don't understand what leading means, since those are your words and not mine at paragraph 96 of your first report, PDF page 43. But we'll move on. In modeling the fair market value based on discounted cash flow, you observe that you're looking at the cash flows to equity holders, right?
Right.
Okay. And that's because the claimants here held equity, right?
No, it's actually because the claimants held the entire value of the project. And what we do is recognize the fact that once that in order to fund this project and build it, they would borrow money from loans, via loans or project finance. And that would then go to repay those loans. And therefore, what remains is the equity.
So the claimants held the entire value of the project. By that, you mean as of March 14, 2017, their equity stake in the project was 100%.
Yeah, but also the right to the project is 100%. So if they chose for some reason, which would not be economically sensible, to fund the entire thing with equity and tell DEG to go home, they could do that. If they thought that was a good idea, then we wouldn't be deducting the debt and we would be doing free cash flows to the firm, not free cash flows to equity. So the reason why we're doing free cash flows to equity is not because of them having equity rights to the project, is because they have the entire rights to the project, and the particular way in which these projects get funded is with a large amount of debt. So therefore that needs to be deducted. Otherwise, we would be compensating claimants for amounts that would otherwise go to the financial institution.
Claimants weren't intending to fund this project only through debt, though, were they?
No, they would use equity and debt.
And their equity investors would take how big of a stake in the company? Do you recall?
It depends. There's correspondence suggesting 30%, and there's correspondence suggesting they would be willing to commit 100% of the equity.
me rephrase that question because I think maybe you didn't understand me. The equity investors who are going to join claimants in this investment, we're asking for what percentage in exchange for their equity investment?
Are you referring to Interjects?
Yes.
Okay, so we're talking about Interjects. Interjects was looking at contributing 70% of the equity.
Thank you. But as you pointed out, as of March 14th, 2017, it was claimants who held 100% of the equity in Mamacocha, right?
Correct.
And you assume the project would have achieved financial close as scheduled in May 2017, right?
Correct. My colleague will address the questions on timeline of the specific milestones, as he's the one who's going to cover the discounted cash flow details, but yes.
Okay, then I'll put this next question to Mr. Cardani, and thank you for that clarification. So, Mr. Cardani, financial closing would have included Interject's investment in a 70% equity stake of the project, right?
What do you mean by financial closing, and what document in particular are you referring to?
So I'll jump you back up to the question I just put to Mr. Delapiani, which is that financial closing was scheduled on 15th May 2017 or thereabouts, in May 2017. Do you agree?
Well, I would like to see the document first that you refer to, indicating the financial closing on May 2017.
There are several documents in the record, including the reply. Have you read the reply?
I read some of the portion of the reply and some of the appendices. The record is extensive. That's why
Okay. We'll go ahead and bring up the reply for you so you can see that. But I also would just like to get a sense of how much you did understand from reading the reply. Are you aware that there was a milestone in the project referred to as financial close or financial closing?
Yes.
And are you aware that financial closing was a necessary prerequisite to complete the project?
Well, financial closing was one of the milestones to move forward with the project.
So I take it you agree then, Mr. Cardani, that financial close was a prerequisite for completion of the project, right?
Well, I'm not entirely sure by prerequisite, what you refer to, if it's a legal issue or just an operating issue. Of course, to complete to start construction of the project, the funding should have been available. And what I understand from the record is, as of the date of valuation, funding would have been available. There is a widespread documental evidence and as well as expert testimony by Mr. Whalen that support the reasonableness and likelihood that financial closing would happen and the project would move forward, at least as of the date of valuation, which is our assumed or instructed date.
And do you know when that financial closing was supposed to take place?
I don't recall exactly the date. So that's why I was asking you to, point me to a document, just because I don't want to.
We'll do that. Just give my colleague a second here. I think she's having a little trouble locating that part of the reply. There we go. All right. So this is paragraph 92 of claimant's reply. Does this refresh your recollection of when financial close was scheduled?
I'm sorry, we're not seeing, hold on a second. Maybe it's.
Oh, must be a lag on the screen.
1 second, please.
Oh, here. Negotiation confirmed that financial close in May 2017 and construction would begin no later than July 1st, 2017. No, yes, I see that. And thank you for pointing to this statement in your reply.
You're most welcome. It sounds like someone's mic isn't muted, by the way. Okay, so let's get back to business then. in assuming that the project would be completed, you are assuming that it would have achieved financial close as scheduled in May 2017, right, Mr. Cardani?
Yes, correct. Okay.
Okay. Now, financial close as contemplated would have included Interject's investment in a 70% equity stake of the project, right?
I don't think that's necessarily true. I understand from the testimony of Mr. Jacobson that in the case in which Interject did not provide equity investment, and that we know happened due to the measures, Mr. Jacobson was in the position to contribute equity. There is his testimony and also documental evidence on record to support that.
So it's your understanding that absent the measures, Interject actually wouldn't have completed their investment in the 70% equity stake company?
Can you repeat the question, please?
Yeah, is it your understanding that Interject had, let me start over. Is it your understanding that when claimants achieve financial close in the but-for counterfactual scenario, it would not have included Interject's investment in a 70% equity stake of the company?
In our but-for world,
Mm-hmm.
in our but-for world, we do not assume Interject is an equity investor in the project.
And what is your basis for assuming that the Interject transaction would have failed, Mr. Cardani?
That's not what you said.
And that,
Excuse me, I'm asking the question of Mr. Cardani.
Yeah, I'm sorry, but
can you repeat it, please? I just want to make sure I fully understand, and I don't.
Mr. Cardani, what is your basis for concluding that the Interject transaction would not have been consummated as part of financial close?
I'm not sure I have all of the element to respond to that question. I mean, as of March, so let's take a step back. As of May 2017, Interject, at least as far as we understand, was not any longer standing behind the offer or the February 2017 offer, right? I think with that we agree. So our valuation assumes a but-for world, and the valuation date again is prior to that financial closing that you're talking about, which is May 2017. Our valuation assumes that Interject was not part of the equation at that point, and that claimants would move forward with the project and just obtain leverage from the financier or the development bank called DEG.
And I'm just asking you, Mr. Cardani, what's the basis for your assumption that claimants would proceed without the equity investment from Interject?
So the basis, I can probably point you to a few paragraphs of Mr. Jacobson witness statement, in which he actually explains that he would have moved forward with the equity contribution. If I don't recall incorrectly, and maybe somebody can correct me if I'm wrong, around paragraph 41 of Mr. Jacobson witness statement, that's clearly explained. And there is also, I believe, communication or an email between the executives of Latam Hydro stating that. If I don't recall incorrectly, is document C2113. It's one of the documents that I reviewed that kind of provided us, that Counsel for Claimants provided us with. So our understanding based on the facts, and we understand that the facts are, maybe in dispute. So I'm not, in the position to take an opinion with respect to those facts. But our understanding based on the statement of Mr. Jacobson in his witness statement, I think is his first witness statement, I think we also cited in our report, actually, and documental evidence on record, the project would have had equity from Mr. Jacobson to move forward in the but for world. That's our position or our understanding.
So we'll go ahead, since you seem very fixated on Mr. Jacobson's testimony instead of the rest of the briefing, we'll go ahead and pull up Mr. Jacobson's first statement. Just give us a second here. Is this a paragraph you were referring to?
Well, I would need to go back and look. I think there is a series of paragraphs that are relevant. So I probably would need to review the portion and potentially our expert report in which we cite the relevant statement.
Okay, review what you need to review and then let me know what you were intending to refer to, please.
Yeah, we can't see her.
Hold on, let me. So I need to, can I open a copy of the witness statement to actually review it?
You may. Just let me know when you're ready. Oh.
Okay, well, I think, I'm not sure, honestly, which portion of the witness statement, but I can point you to the document I was referring to. If
That's
that
okay. I'd like to stay on the witness statement.
And in general, I want to make a point about our valuation that I think is important. Our fair market value analysis.
Mr. Cardani, I'd love to let you make that point, but I actually just want to get an answer to my question first. So let's go ahead and do this. And your counsel can definitely take you to that document and redirect if it's relevant to this examination.
Okay.
Which remains to be seen. But since we've got Mr. Jacobson's statement up on the screen, let me help you out a little bit here with the context. If we could please scroll up to paragraph 40. And let me know when you've had a chance to read that paragraph, Mr. Cardani.
Yeah, I see it. Yeah, thank you for the.
Okay. So here is Mr. Jacobson testifying that Latam Hydro expected to finalize the investment with Interject sometime in March 2017. The loan agreement with DEG sometime in May 2017. And the EPC contract with GCZ in time to begin construction on or before July 1st, 2017. Do you understand that Mr. Jacobson is testifying here that Latam Hydro expected to finalize the investment agreement with Interject?
That's what he says, yes.
So what is your basis then for assuming that in the but-for world, financial close would have proceeded without Interject's participation?
Well, we have I think, and
excuse me, Mr. President, I apologize for interrupting, but I do have an objection to this line of questioning. Ms. Endicott is mischaracterizing Mr. Cardani's testimony. Mr. Cardani never said that he assumed Interject wouldn't invest. His testimony was, in our but-for world, we do not assume Interject is an equity investor in the project. I've been very patient with this line of questioning, but this entire line of questioning has been based on a mischaracterization of testimony.
Ms. Endicott, please ask the question according to what the expert has said.
Sure, I'll go ahead and just ask the question according to what Mr. Zeballos said. So I believe Mr. Zeballos just testified, Mr. Cardani, that your testimony.
I'm sorry, Mr. President, I'm going to object again. I did not testify. I was repeating the witness's testimony. I don't appreciate that characterization. Mr. Cardani's testimony at line 92048 of the transcript says, in our but-for world question, in our but-for world, we do not assume Interject is an equity investor in the project.
So then put differently, my question is, what is your basis for not assuming that Interject's invested in the project as of financial close, Mr. Cardani?
I'm sorry, I don't understand the question, to be honest.
Sure.
I mean,
I do, if you want me to pick it up.
No, that's okay. The question was put to Mr. Cardani. And
Yeah, but I happen to understand. I can provide an answer to the tribunal.
Mr. Delapiani, the question is directed to Mr. Cardani. Mr. Cardani should answer.
what is the basis for not assuming that Interject is invested in the project as of financial close? I think that's irrelevant to our analysis. So I'm not entirely sure what else I should say with respect to that question.
Can you tell me why you believe it's irrelevant to your analysis that Interject would not have, that you can't assume that the transaction with Interject would have been successful?
Because to the purpose of evaluation, it doesn't matter if Interject is involved or not involved in the Mamacocha project.
Ms. Endicott, may I ask you the question for 1 second? Mr. Cardani, could you please answer the question, does your valuation assume that Interject was in it or out?
It assumed that it was out.
Out, okay. Endicott, please take it from there.
Okay. Thank you, Mr. President. And thank you, Mr. Cardani. Financial closing would have also included DEG's agreement to lend money, right?
Yes, that's my understanding.
Okay. So DEG would have held debt in the project, right, Mr. Cardani?
Yes.
And Mr. Cardani, you assume the project would have achieved commercial operation on 1st January 2020 in your model, right?
That's correct. Yes.
And that model is modeling what would have happened in the counterfactual scenario, right?
But for world, yeah, but for scenario.
So you accept that even in your but-for world or counterfactual scenario, claimants would not have achieved commercial operation by December 31st, 2018, right?
Commercial operation, it would have started producing at the end of the construction period, and which we assume being at the beginning of 2020.
Okay, so you assume that they would not have achieved commercial operation by December 31st, 2018, correct?
Well, I want to point you to our understanding and instruction for that. And correct me if I misunderstood your point. Just to clarify, if you look at our first report on footnote 15, we have an instruction by counsel to assume that addendum 1 and addendum 2 are still in effect as of the date of valuation. And the commercial actual date of, according to these two documents, these two addenda, we understand that the actual date of commercial operation startup is March 14, 2020.
And you assume that the project will be in operation for 40 years, from 1st January 2020 until 1st January 2060, right?
40 years of operation, yeah, from our assumed start date of operation.
So your DCF model calculates the cash flows to equity holders over 40 years and then discounts the value of those cash flows back to March 14th, 2017, right?
Yeah, as a standard DCF is supposed to do. Yes, correct.
And as of March 14th, 2017, DEG had not signed a contract to loan money to claimants, right?
I don't recall exactly the date, but again, what I would like to point you is the expert testimony of Mr. Whalen, who actually is an expert in project financing. And I think his conclusions indicate that the project would have been able to obtain financing to meet the deadlines. So I'm probably not the right person to ask those questions. That's our understanding of what the expectation and likelihood of obtaining financing was as of the date of valuation.
So I'll just ask again, especially since Mr. Delapiani said you're the timeline expert. As of your valuation date, March 14, 2017, DEG had not signed a contract to loan money to the claimants, correct?
There was a term sheet dated March 6, I believe, outlining the condition of the DEG loan. And there is expert in project financing that indicates that the DEG loan was on track to be finalized in order to start the construction of the project. That's our understanding, based on the looking from the perspective of the world as of March 14, 2017, which is our viewpoint.
So Mr. Cardani, this will go much faster if you can just answer my question, which was, as of March 14th, 2017, DEG had not signed a contract to loan money to claimants, had it?
I think I answered your question, qualifying that DEG had a term sheet on March 6 that is included in our backup. And I understand from the witness testimony of Whalen that they would have been able to reach an agreement on time to develop the project.
Mr. Cardani, is a term sheet a signed contract to loan money to claimants?
No.
Mr. Cardani, does Mr. Whalen testify that as of March 14, 2017, DEG had signed a contract to loan money to claimants?
I think you're mischaracterizing what I said. I said clearly that he was, based on the testimony of Mr. Whalen, and probably he would be the best person to respond to this question. We are just citing to him. It was likely, as of the date of valuation, that the DEG loan would be finalized on time to obtain the money to construct the project. So I think you are trying to put in my mouth words that I didn't actually stated.
I'm actually just trying to ask you a question and get an answer, Mr. Cardani. And my question was just whether or not Mr. Whalen, whose testimony you clearly reviewed, testified that as of March 14th, 2017, DEG had signed a contract to loan money to claimants.
Again, no, but it was likely to be signed. I think I've said this multiple times. I responded to that question at least 3 times.
As of March 14th, 2017, DEG had not disbursed any funds to claimants, right?
No.
So as of March 14th, 2017, the project had no debt, correct?
Correct.
As of March 14th, 2017, Interject had not invested in CH Mamacocha, right?
Correct.
So as of March 14th, 2017, CH Mamacocha had not received any of the $17.8 million cash investment proposed in the Interject's letter of intent, right?
No, because Interject had to walk away from the project, we understand due to the measure at issue in this case.
After performing your DCF analysis, you concluded that assuming the project does operate, excuse me, let me start that over for our record. After performing your DCF analysis, you conclude that assuming the project does operate until 1st January 2060, the cash flows to equity holders discounted to March 14, 2017 would be 25.075 million, right?
That's correct.
So it is your view then that a well-informed buyer operating absent coercion would have paid 25.075 million for 100% of the equity of the CH Mamacocha project on March 14th, 2017, right?
That's the fair market value of the project as of that date. Yes.
Are you aware that on 30th January 2020, the Peruvian courts issued the Amparo ruling, finding that claimants had failed to properly secure their environmental permits and declared the RER contract void ab initio and invalidated the final concession?
I think I understand that fact. Yes.
Are you aware that on 24th February 2021, the Peruvian courts affirmed that decision?
Yes, I understand that.
Are you aware that neither of these decisions is challenged as a breach in this arbitration?
Those two, are not part of the measures. I think the measures, if you want to go back to the specifics, are those included in our first reports on paragraph 3 and 4. If you want, we can read them together.
That's okay.
They don't include the Amparo. They don't include the Amparo.
Thank you. So if an event isn't included as one of the measures, then it exists in the counterfactual.
Okay, stop for 1 second. Mr. Lepani, are you all right?
Me? Yeah, sorry, I've been sick for a week. A poor colleague has had to endure me, but I'm fine. Thank you.
If I need to stop, tell me. Let me know.
Thank you very much. I will.
Right. Ms. Endicott, shall we break it for 4 minutes? When you finish your line of questions on this subject.
Yeah, in just a few minutes, a break will be fine. Thank you.
Let me know when you want to stop.
And the same goes for me, Mr. Delapiane. If you're feeling sick, please do interject.
I'm okay.
Okay. So if an event isn't challenged as one of the measures, Mr. Cardani, it exists in the counterfactual scenario, doesn't it?
If an event isn't challenged, exists in the counterfactual, can you be a little bit more specific?
No.
What event are you talking about?
So you just explained to us, and to avoid an objection from Mr. Zavallos, let me just read back what you said. Those two, referring to the Amparo decisions, are not part of the measures.
Yes. So you're referring to the Amparo in your question.
So I'm asking you.
I'm just asking you to clarify the question because I was not sure whether you were referring to the Amparo or something else in the counterfactual.
We can talk about the Amparo, but an event like the Amparo rulings that are not challenged as a breach exist in a counterfactual scenario, don't they?
Yes.
Using your DCF model, what would the value of 100% of the equity in the CH Mamacocha project have been if it ceased operating on the 24th of February, 2021?
Well, what are the assumptions of your hypothetical analysis?
Well, we're in the counterfactual scenario that you posit, and we're now adding a piece of information which was not alleged as a breach, which was a decision on the 24th of February, 2021, affirming the nullity of the RER contract and affirming the revocation of the permits for the project.
Okay, yeah.
And I'm just asking you, at that point in your counterfactual scenario, which is 24th February, 2021, what would the value of 100% of the equity in the Mamacocha project have been if it had ceased operating on that date?
The counterfactual scenario starts as of March 14, 2017. So a willing buyer or willing seller looking at the project as of that time would take into consideration the information available about the amparo and factor into the fair market value of the analysis, which is exactly what Interject and DG did. And we have information about it. So effectively, assuming that as the date of valuation, March 14, 2017, which is our date of valuation, and assuming that there was a proceeding in place, the value of the Mamacocha project would be the same. 25, the fair market value of the Mamacocha project, excluding the other components of damages, is about $25 million.
That's based on your DCF model, right?
It's based on the DCF model and is based on the assumption and information available to a willing buyer and willing seller. It's based on basic fundamental of, efficient markets. So if the willing buyer and willing seller have a certain specific amount of information as of that day, they transact based on that information. And that's reflected exactly in our analysis.
So
as it is reflected also in Versant analysis, by the way, but forward is the same in the claimant's position and the respondent position.
So your DCF model is assuming operation of the project in the counterfactual scenario until 2060, and then discounting the value of those cash flows back to the valuation date. I'm just asking you, if instead of assuming operation in the counterfactual until 2060, you assume the operation extended only until February 24th, 2021, and then you performed the same analysis, discounting the cash flows back to the valuation date, what would the value of the project be?
Well, that is an hypothetical that doesn't have any bearing with the reality. So let me just qualify it, right? So if you instruct me to assume that the project would be in operation for a lesser amount of years, the value would be lower. I don't know how lower, but I'm just want to emphasize the fact that this is an hypothetical and is entirely inconsistent with the information available to the parties as of the date of valuation. So it's irrelevant for calculating damages in this case.
The cash flows would be negative, right?
The cash flow would be negative? I don't know. I don't know if the cash flow would be negative. Again, this analysis, which is entirely hypothetical, entirely misrepresents the information set as of the date of valuation, on which we agree with the opposing expert. So maybe you can ask them what they think about it. What I can tell you is that the value of the project would be less under this hypothetical, unrealistic or unrealistic assumption, because as of the date of valuation, a willing buyer or willing seller would not know about the information related to the apparel proceeding that happened at a certain point in time later.
In the event where ongoing or future operations of the project would have been in jeopardy even without the breaches, you'd agree that the appropriate measure of damages may actually be the asset value of the company, right?
I wonder if you could repeat that question. It did.
Sure.
For the reporter, thank you.
In the event where ongoing or future operations would have been in jeopardy even without the breaches, would you agree that the appropriate measure of damages may actually be the asset value of the company?
No, I disagree.
Okay, that's interesting because at footnote 171 of your first report, you state that the liquidation value will tend to underestimate the future value of the business, except for situations where ongoing or future operations would have also been in jeopardy, even without the breaches. Do you know, Mr. Cardani, what the value of CH Mamacocha's assets were on 14th March 2017?
We need to go back and do the analysis, but it would be an entirely inappropriate analysis to do it that way.
Thank you,
Because,
Mr. Cardani.
Because you're asking me about the cost approach, which we fundamentally agree with the opposing side that is not the right approach. So I disagree in the first place, in the first order of my first order of reply to your point is that we should not use a sunk cost analysis in this case, and Versant agrees with that. Okay, so I don't see any utility in calculating or any validity in calculating damages using a sunk cost approach in this case, under any assumption. What we are asked to do is to value the project as of the date of valuation. As of the date of valuation, the appropriate method is the discounted cash flow. And on this one, it's undisputed. It's undisputed in this case, and it's undisputed in prior cases related to this matter. So that's the go-to approach, a reliable approach to calculate damages. There is an alternative approach that looks at the investment value in the project, okay, which was part of our second, like the very last part of our presentation. How much money was invested into the project, and what would have been the return generated by those money to make the claimants full according to the principle of reparation.
Are you finished, Mr. Cardani?
Yes.
Okay, then, Mr. President, I think we can take that break now.
In the examination, you were directed the questions to Mr. Cardani, and I invited him to answer certain questions. You remember that break? But could you please read paragraph 23 of PO6, which
sure.
So what I mean is that the questions are basically addressed to the leader, which I understand Mr. Della Piani to be leading expert, or lead expert, sorry, I should call it. And then he can distribute the question to himself or to Mr. Cardani.
We can certainly proceed that way. I had just understood Mr. Della Piani as saying that on these questions of dates, Mr. Cardani knew the answers. So.
Exactly, no, but it's in the context of what I directed him to answer you, Mr. and him, Cardani, okay. And I would like to put it in proper context. So my own direction to put in proper context of the PO6, paragraph 23.
Okay. On each question, the leading expert can decide who answers.
Yeah.
On each question.
That's what it is. Okay. Thank you. We have a recess until.
Mr. President, I have one point of order then on that clarification, which is that since Mr. Della Piani did want to give a response to that answer, that he be allowed to. We can do that when we return from break, or we can do that now if Ms. Endicott wants to take us back to that question in the record, or I can take a few minutes and find that question in the record. But if Mr. Della Piani would like to give a response to that question, I think he should be allowed to.
Yeah, exactly. So if you go back to the part in the transcript where it is, then can you transfer inform Ms.
If I may interject for just 1 second, the question in which Mr. Della Piani asked to give an answer was about Mr. Cardani's testimony. So I really don't think that's appropriate.
That is not. I'm sorry.
I'm in the tribunal's hands.
No, okay.
I'm sorry, that is a mischaracterization of what happened. You can go right to the transcript and see exactly what it said. Mr. Della Piani tried to give an answer, and he was interrupted and instructed.
Counsel,
question you have, Mr. Cardani.
Ms. Endicott, may I ask you to go back to that particular part where I
Sure.
And then can you reenact the Q&A? If I may invite you to do that. This is tribunal time, because
Sure. Just a moment.
No. This is when you do the question and answer there. There's tribunal time, because
okay.
I think I was not clear in my directions in the context of PO6 and paragraph 23. So I would rectify that. Okay.
Sure. I'm just scrolling.
All right. Okay. No, okay. Take your time. We have 15 minutes.
You want to just pick up there?
Yeah.
Okay.
Let's take a break. 15 minutes. Gentlemen, you are under testimony. You're not allowed to discuss the case with anyone. Right. Recess until now. It is 16:10 CET.
Thank you.
Thank you.
So this is the reporter, and I was wondering why no one spoke up today, because now we're doing English testimony and no one has said anything about that pause 3-second, 5-second rule. So yeah, I thought it was bad. Yeah. Yeah. I will definitely say it as soon as I see the chairman, the president. No problem. Okay. No, I will. Thank you.
Yeah, Laurie, blimey, I would have leapt in if I'd been you by now.
Oh, it was fast and furious, but I just wondered why they weren't enforcing that same rule when it's been in English. So I'll find out, or I'll mention it.
Ms. Endicott, before you start with your reenactment, I get an urgent message from the interpreters, and they asked us to avoid overlap and to still do the 3 seconds, or actually 5 seconds, as we yesterday said, time between question and answer. Mr. Della Piana and Mr. Cardani, same applies to you. Wait for 3 to 5 seconds before you answer. Yeah. Right, then Ms. Endicott, can you when you start your reenactment, if I may call that way, on the tribunal's time, as I mentioned to you, could you tell me to which specific part of the transcript you are referring?
Sorry, Alvarian. Okay, no, we didn't have transcript in English. It appears right now.
I wasn't sure if he was ready to be on the record or not. I should have asked. Sorry, Mr. President.
Okay. Do you now you want me to reenact again?
Yeah. Start over. Sorry.
No. Okay. There's no. So I asked both Ms. Endicott and the experts, witnesses, to observe the 3 to 5 second rule between Q&A.
Will do.
Yeah. Okay. I see Ms. Endicott is now counting 3 to 5, but before you do that. Okay, Ms. Endicott, so you do now the reenactment on the tribunal's time. could you please make a specific reference to which part of the record you are now doing the reenactment?
Certainly, and I promise not to do any strange voices, but let's go ahead and take it from transcript page 66, line 8, at minute 9:28:39. Me, Ms. Endicott. So what is your basis then for assuming that in the but-for world, financial close would have proceeded without Interject's participation? Mr. Cardani begins to answer, well, we have the, I think. Mr. Zabayas interjects, excuse me, Mr. President, I apologize for interrupting, but I do have an objection to this line of questioning. Ms. Endicott is mischaracterizing Mr. Cardani's testimony. Mr. Cardani never said that he assumed Interjects wouldn't invest. His testimony was in our but-for world, we do not assume Interjects is an equity investor in the project. I've been very patient with this line of questioning. The entire line of questioning was based on a mischaracterization of testimony. Mr. President.
Perdón.
Ms. Endicott.
Disculpen que interrumpa. Soy el tenotipista en español. ¿Podría leer un poco más despacio, por favor?
Claro.
Okay. Ms. Endicott, so half the speed, please.
The president interjects and says, Ms. Endicott, please ask the question according to what the expert, Mr. Cardani, has said. Ms. Endicott, sure, I'll go ahead and just ask the question according to what Mr. Zabayos said. So I believe Mr. Zabayos just testified, Mr. Cardani, that your testimony, Mr. Zabayos, I'm sorry, Mr. President, I'm going to object again. I did not testify. I was repeating the witness's testimony. I don't appreciate that characterization. Mr. Cardani's testimony at line 92048 of the transcript says, in our but-for world, question, in our but-for world, we do not assume Interjects is an investor in the project. Ms. Endicott, what is your basis for not assuming that Interjects invested in the project as a financial close, Mr. Cardani? Mr. Cardani, I'm sorry, I don't understand the question, to be honest. Mr. Delapiani, I do, if you want me to pick it up. Ms. Endicott, no, that's okay. The question was put to Mr. Cardani. Mr. Delapiani, but I can provide an answer to the tribunal. President, Mr. Delapiani, the question is addressed to Mr. Cardani. Mr. Cardani should answer. Okay. And then Mr. Cardani gives his answer. And I would just like to clarify that as the record shows, this was a question to Mr. Cardani about his testimony for a question that he answered. And therefore, I asked the tribunal to take that into consideration when deciding whether or not Mr. Delapiani should be allowed to testify about Mr. Cardani's testimony.
Yeah,
thank you.
Okay, but Ms. Endicott, can you now ask Mr. Delapiani to answer the question, because as he offered. Mr. Delapiani, can you answer the question? Because you interfered there. You said, look, I would like to answer the question.
Thank you, Mr. President. Let me make sure I read the question. It was asked 3 times in different ways. So I'm going to read the last one, I guess, is the one that is in discussion. Question was, what is your basis for not assuming that Interjects invested in the project as financial close? The answer is that we did not make an assumption one way or another about Interjects' participation in relation to our but-for analysis. Our but-for valuation, the fair market valuation, does not make an assumption about Interjects. It is Interjects neutral. It says, what are the cash flows, what are the revenues and costs that this project would have achieved? And we do that so that we can obtain the fair market value, also understood as the intrinsic value, the value of the cash flows the project can generate. Our valuation, once again, is Interjects neutral. So this idea that this Interjects would have been assumed to close or not assumed to close, assumed to the transaction have failed as it was represented before, these are not assumptions that are made or are relevant to our DCF valuation. Thank you for giving me the opportunity to clarify that.
Ms. Endicott, this ends the reenactment. You may continue your cross-examination. Now it's your time again. I think you need to do an...
Thank you. Mr. Delapiani, you just testified that your model is Interjects neutral. Do you consider excluding Interjects' investment, which was planned to take place, to be neutral?
Once again, it doesn't consider it one way or another. You just said that considering it excluded, whether it's neutral or not, but I'm not sure what makes you say that it's being considered excluded. It is not considered one way or the other. And once again, you've put words in our mouths that we are considering it excluded when that's actually not what we're doing. We are simply calculating the cash flows without consideration for whether the investment would come from Interject or not, which is not the same as to say that the transaction would have failed, would have not closed, or that we're excluding Interject from the mix. They're different things. Very different things.
Oh, are you finished?
Yes.
Mr. Delapiani, would you agree with me that included is the opposite of excluded?
Generally speaking, sure.
Did you include the Interject's investment in your DCF model?
We did not model the DCF in a manner that considered the identity of any of the buyers, whether it's Interject, Latam Hydro, Mr. Jacobson, or anyone else. That's why the distinction is so important, because fair market value is agnostic to any of these people.
Did you include the Interject's investment in your DCF model?
No, but we did not assume it failed to close. We did not assume that it didn't go through. You see, these are very different things. That's why I said, generally speaking, excluded and included may be antonyms, but they're actually not in this case, because it's not the same to say that Interject has walked away or that Interject is not being considered and so on, than to say that none of the parties, that the valuation is agnostic to the identity of the parties, which is required by the fair market value standard.
We've talked a bit about fair market value, haven't we, Mr. Delapiani?
Yes.
And when you're considering the buyer in this fair market value scenario, you're considering the buyer of what claimant would have been selling, right?
No, you consider the 100%. You look at the buyer in terms of understanding whether the analysis shows that there would be, from the point of view of a buyer, pardon me, from the point of view of a buyer, the analysis makes sense or not. You don't consider the buyer, whether it's 2% or 98%, that's irrelevant to the exercise, because you're seeking to determine the value of 100% of the asset. The identity of the buyer is irrelevant, and in fact, the existence of a potential buyer, and this is well established, that in the literature and in financial economics, the identity and the existence of a buyer is also irrelevant. So you might have an infrastructure project that costs $5 billion to build, and you might say, how many companies in the world could possibly buy that, have the deep pockets to acquire that? It doesn't matter. That is not relevant to the fair market value standard. We do not need to identify a potential buyer, a prospective buyer. We need to understand the economics from the point of view of a putative buyer and a putative seller.
The damages that you're calculating here, you testified, are based on fair market value, right?
Correct.
And fair market value is the price at which a willing buyer would pay for that company, right?
Yes, that's exactly why the importance of looking at the offers by potential buyers from the lens of those prospective buyers, as I showed this morning.
But the damages that claimant receives, which would be the price, ought to correspond to the amount of that company the claimant owns, right?
Yeah, 100% of the company was owned by claimant in this case. So yes, we're valuing a share of 100%. That's what we're seeking out to do, both us and Versant.
Now, in your report, you also refer to the intrinsic value, in quotes, of the Mamacocha project, right?
Yes.
Is that the same as the fair market value of the Mamacocha project?
In For all practical purposes, yes, we understand it to be the same. Intrinsic value, some treaties have it as valeur réelle or real value in French. Pardon, my French is horrible. Fair market value, fair value, market value. The different legal authorities and economic and financial economics authorities describe it differently, but they're all seeking to determine the intrinsic value, which is the cash flows and the money that it can produce, that asset, right? The assets have value because of what they can generate in the future, whether by selling them or by exploiting them. And in this case, it's by exploiting it. That's the intrinsic value, is to determine what is it that one can actually squeeze out of this asset, so to speak.
So if the intrinsic value is the same as the fair market value, then the intrinsic value is the price that a willing buyer would pay and a willing seller would accept, right?
In equilibrium, once a transaction is consummated, fair market value, if it's under arm's length, under the conditions, no distress, no coercion, et cetera, then one seeks to understand how those two coincide. And yes, when there's transparent information and the buyers know what they're buying and they can see that they need to deploy, in this case, $25 million or more, and there will have to be revenue streams to overcompensate for that, meaning to make at least that and more to get a return on that investment. Then we have information to actually say, I see how the intrinsic value can become the fair market value. That's exactly the exercise we pursued.
Now, in calculating your DCF, I believe, I'll put this question to you, Mr. Delapiani, because I believe Mr. Cardani answered it earlier, but in calculating your DCF, you look at free cash flows to equity holders, right?
Correct.
That's the money that flows back to equity holders discounted to the valuation date, right?
Correct.
And you explain that in order to apply the DCF method using free cash flows to equity holders, quote, we explicitly calculate the free cash flow available to equity holders after taking into account all payments to and from debt holders, PDF page 45, paragraph 102 of your first report. So in calculating cash flows, you work on the assumption that debt holders get their cash first, right?
Yes, that is the normal assumption that debt has seniority over equity.
So you'd agree that debt holders have a direct claim on the company's free cash flows, whereas equity holders can only receive residual free cash flows after all those other obligations, including debt, have been satisfied.
In general terms, that's correct. There is all kinds of interim mezzanine structures, but for purposes of this case, we have a very simple direct observation, which is you have total firm project cash flows, part goes to debt, the rest goes to equity.
Thank you. And just for the record, I was quoting from Versant's first report, paragraph 87. In fact, debt holders are always paid out before equity investors, right?
I think I just answered that, saying generally yes. In this case, that's the construct that matters. There's obviously all kinds of very complex structures that financiers and lawyers have designed to, get around all kinds of issues.
But you're not talking about those structures here, right?
Like I just said, this has a very simple framework. Total firm value gets first to the debt holders, then to the equity.
So in the event that there's not enough money left in the company coffers to pay both the debt holders and the equity holders, the debt holders get paid and the equity holders might not, right?
Yeah, that's why the cost of equity is higher than the cost of debt. It's a more risky instrument. And in this case, both Versant and us conduct a free cash flow to equity in order to reflect that, that the debt gets paid first. Yeah, that's 100% true.
So equity holders demand a higher rate of return for their riskier investment than debt holders do, right?
Somewhat. It depends on the place at which and the time at which they're investing. So we have to compare apples and apples, as my colleague explained this morning. But all else equal, as of exactly the same point in time, in the same stage of the project, what you said would be correct, that the debt holders would require a return lower than the required return by the equity holders in that same place and time at the same stage of development of a project. This cannot be generalized across the lifespan of a project, which is what our colleagues did in making that comparison.
The rate of return for equity holders is sometimes called the cost of equity, right?
Well, now we enter into very dangerous territory. It is sometimes called cost of equity, to answer your question, but we have to be very careful to understand what we mean by return required by equity holders, because the cost of equity seeks to understand what is the minimum required return by equity holders that satisfies their the risk profile of that particular investment, which is not to say that equates to their hurdle rate or expected rate of return or internal rate of return of the project. These are all terms which people use sometimes interchangeably and should never use interchangeably. They're not.
Mr. Delapiani, just to be clear, I didn't ask you about the required rate of return. I just asked you if the rate of return that equity holders receive is sometimes called the cost of equity.
Yes, your question was even more general than required rate of return. That's why I made the clarification.
Mr. Delapiani, your count is very quick. I don't think it's 3 seconds. And
sorry,
if you could speak a little bit slower for the interpreters, greatly appreciated. Thank you.
Thanks for pointing it out.
Mr. Delapiani, do you agree with Professor Damodaran that the cost of equity can never be lower than the cost of debt for any firm at any stage in its life cycle?
I would have to look in what context that is written in those words by Mr. Damodaran. But as I said before, to say that at any point, at any cycle, I am surprised by that generalization, because Professor Damodaran would understand that if you buy into a project before it's built as an equity holder, you might require a 5% or a 20% return. I don't know what the situation might be, but fast forward 20 years when the project is in operation, you might require a totally different return. And to say that those are always going to be higher or lower than debt rates as of the other points in time is a very dangerous generalization I would not agree with at all. And I would have to look at what he wrote, but I don't think that's what he meant.
So we'd all like to look at what he wrote in just a second. But just to clarify, is it your position in this arbitration and before this tribunal that the unlevered cost of equity for a particular project may be lower than the tax-free cost of debt?
As of what time? As of the time when the project is unlevered? Absolutely. I'm sorry, as of the point in which, let me clarify the answer. The unlevered cost of equity of a project will be lower than the levered cost of equity of a project. Now, will it be lower than the cost of debt when the project is still in construction or pre-construction? We don't know. In this case, it's not. But that's nothing surprising about that. As you saw from my presentation, the cost of equity evolves. So does the cost of debt. So you cannot compare them across different points in time because the project is in such vastly different status of development.
Mr. Delapiani, you started talking about the levered cost of equity. So I'll just ask my question again. Is it your position in this arbitration and before this tribunal that the unlevered cost of equity for a particular project may be lower than the tax-free cost of debt?
As of that time, it is not my position that the unlevered cost of equity will result in a lower, it would be consistent with a cost of debt that is higher. And that is exactly what we pointed out, that you cannot compare an unlevered cost of equity in a project with a debt rate for a project that is 70 or 80% levered. The 7% of DEG, 736% of DEG, is a rate for a project that's going to be mostly 70 to 80% debt financed. DEG, ask DEG how much, what the rate would be if you wanted 1% financing. It would certainly not charge you 7%. they would charge you some other rate, presumably and very likely below 5.7%, because that would be commensurate with an unlevered project. You see, the thing is, by calling it, as you just did, and by referring to an unlevered cost of equity, you're looking to a project that has no debt. And if it has no debt, as you just told me, who is responsible and owns 100% of the cash flows? The equity holder. There is no debt. There is no risk to the equity holder of getting paid what you call the residual value. They get all of it. And if they get all of it, they're just like a debt holder. So you cannot compare an unlevered cost of equity with a cost of debt of a project that is highly leveraged.
Let me ask it to you this way, Mr. Delapiani. Let's assume you own a company and you're looking to finance it. And you approach two potential investors. One of them says, I can make an equity investment in your project. And the other says, I can make a debt investment in your project. Do you think there's a world in which the equity investor would accept a lower return than the debt financier?
No, and that's why we point out that when you're looking at a project that that has mostly funded with debt, at that point in time, as I showed this morning on page 11 of my presentation, the cost of equity was about 8.5%, 8.54%, because it has 171 debt to equity ratio, based on the fact that all the cash flow is levered. But when you fast forward a few years and you start seeing that, and at that point, so 8.5% is the cost of equity and the cost of debt was 7.36. Then the cost of equity continues for several years above 8% and the cost of debt is at 7%. So this relationship is maintained in absolutely clean terms. Now, what happens after several years? The project becomes delevered, meaning the debt is being repaid. At that point, the equity holder sees less and less and less risk because the project is being de-risked and with it is being delevered. At that point in time, the comparison that matters is an unlevered cost of equity with a market cost of debt, not with the cost of debt of when you are actually looking for financing and only one or two institutions might be willing to give it to you because you're looking for 70 or 80% of the debt. So I think I've answered your question. I hope I've answered your question.
For the Mamacocha project, you and Versant agree that the cost of debt is between 7.06 and 7.36%, right?
We agree with using the interest rate for the construction and first 15 years of operational period as per the term sheet from DEG.
Do you agree that the cost of debt for that project is between 7.06 and 7.36%, Mr. Delapiani?
We agree with using that interest rate as the cost of debt to put into our DCF model. I'm not trying to be difficult in the clarification. I think it's an important distinction, the one I'm making. We have to be careful with the language here.
You then state at footnote 31 of your first report that the cost of equity varies between 5.79 and 8.63%, depending on the effective level of debt in the Mamacocha project between 0% and 63.93%. You draw a distinction there between the levered and unlevered cost of equity, right?
Yes.
So the levered cost of equity is the cost of equity for a project when it also has debt, right?
Correct.
And the unlevered cost of equity is the cost of equity for that project when it doesn't have debt, right?
Correct.
So in the year where the, quote, effective level of debt of the Mamacocha project is 0%, close quote, the cost of equity in your model is the unlevered cost of equity, right?
That's right.
And you state that that cost of equity is 5.79%, right?
That's right.
This is also reflected in your model, which for the record is BRG 003. And if I could ask my colleague, Mr. Alvarez, to pull up BRG 003 and go to the sheet titled Discount Rate Summary, row 21, column I.
I should point out that that's from the first report, and there's some small differences in the second model, some corrections and small changes, but we can use whichever one you prefer.
Do you change the unlevered rate of equity in your second model to be more than the rate of debt on the project?
Well, that's a bit of a loaded question. We don't, I think we can talk about the levered and unlevered cost of equity independently of which model, if that's what you're pointing out.
Do you change the unlevered rate of equity in your second model to be more than the rate of debt on the project?
The unlevered cost of equity in the, sorry, I can't see anything. We're gonna have to put this in a normal view format for me.
Mr. Alvarez, if you can just take the screen down for a minute so that Mr. Delapiani can focus on answering my question. And I'll read it back to you, Mr. Delapiani. In your second model, do you change the unlevered rate of equity to be more than the rate of debt on the project?
Oh, well, the unlevered cost of equity, there is no debt. That's the whole point. By that time, the equity holder is as good as the debt holder. So it doesn't need debt. It doesn't care about that. It's got no leverage. It's got claims on 100% of the cash flows, as you put to me earlier.
Mr. Delapiani, in your second model, do you change the unlevered rate of equity to be more than the rate of debt on the project?
There is no debt, Ms. Endicott. There is no debt. You're comparing something that cannot be compared. I just explained it 3 times. In the event when the project is unlevered, there is no debt. So what debt are you referring to? What cost of debt? You're referring to a cost of debt from 20 years prior or 15 years prior when the project wasn't even built. So if you want to tell me that, if you want me to say that 5.7 is a lower number than 7.06, I can agree with, arithmetically, those 2 numbers being one greater than the other or one smaller than the other. But we're going to have an intelligent conversation about the fact that the cost of equity on an unlevered basis for a project equity holder that has 100% of the claims over the cash flows is or isn't higher than a cost of debt. The question then becomes, what cost of debt? There is no debt at that time.
Mr. Delapiani, I can tell this question is difficult for you, but I just need you to answer it for me. In your second model, do you change?
Ms. Endicott,
Yes.
don't forget the 1, 2, 3, 4, 5 counts. Okay.
Mr. Delapiani, I can tell this question is difficult for you, but I would like you just to please answer for me. Do you change the unlevered rate of equity in your second model to be higher than the rate of debt on the project?
The unlevered cost of equity in the model is not comparable, is not higher or lower. It doesn't exist when there's no debt. It exists when there is, it exists only when there is no debt. So the way you're asking this question, in intellectual honesty, I cannot answer it because you're asking me whether a number is higher or lower than a number that doesn't exist at that point in time in the project. So it is not an intellectually honest answer that satisfies you or anyone if I tell you that 5.7 is lower than 7.06 because they don't exist at the same time.
Mr. Delapiani, I'm just asking you whether you changed the number for unlevered equity between your first model and your second model, such that in your second model, the unlevered cost of equity is higher than the cost of debt for the project. Asking if you made that change. Did you?
You're not asking if I made that change. You're asking if I made that change and you're adding something else. I did not make a change in the model that changes the levered cost of equity, but you're adding a second part to the question, which is in a way that makes it higher than the cost of debt. And I'm telling you that I cannot agree with the premise to that question in an intellectual, honest manner, because that rate of debt does not exist in year 15, Ms. Endicott. And I've answered this 4 times now, honestly.
All right. Mr. Alvarez or Ms. Giraldo, whoever's controlling the screen, could you go ahead and put up, please, BRG-003 sheet discount rate summary, row 21, column I. Okay. And we've got to get to the right sheet, which is discount rate summary. This is income tax. Do you recognize this model, Mr. Delapiane, assuming you want to answer these questions, and not Mr. Cardani?
Yes, I do.
Okay. And you see row 21 is titled cost of equity?
Yes.
Okay. And you see row 18 refers to the debt equity ratio?
Correct.
The debt equity ratio in row 18, column I is 0, right?
Correct.
And what is the cost of equity there listed?
5.79%.
And that's the unlevered cost of equity, right?
Correct. No debt.
Okay. And this is pre-construction in a project that will assume debt for 15 years, right?
Correct.
Okay. Now let's take a look here. So then if we want to get to the levered cost of equity, we're going to apply a debt to equity ratio to that unlevered cost of equity, right?
No, not exactly.
Let's just take a look then at a year where we have debt and we have a levered cost of equity. So if we go to row 18 and we jump from column I over to column J, we see the addition of a 43.42% debt to equity ratio, meaning the debt obligation has commenced here, right?
Yep.
Okay. And if we look at the variables that are going into the cost of equity, and in particular into the beta, we see that the change that is being made there is the addition of a debt to equity ratio, correct?
Yes, but it's not being made directly to that. It's being made to the beta, the coefficient that correlates the market performance to the asset performance. The asset volatility to the market volatility. So the application of the debt to equity ratio is not direct, it's indirect. There's an indirect step, which is the re-levering of that beta. And it's, I understand this may be painful for some, but there's a few permutations involved in getting from one point to the other. It's not just applying, as you said, a debt to equity ratio to the cost of equity.
The only factor that's changing in the calculation of the beta between column I and column J is the addition of a debt to equity ratio, correct?
Yes, indeed.
And if we return to row 21, in the year where the project has taken on debt, we see a cost of equity of 6.48%, right, Mr. Delapiane?
Yes, for that year, that's correct.
Is 6.48% less than 7.36%, Mr. Delapiane?
Yeah, for that particular year, it's lower. The average is 7.42%, as I showed this morning. And this relationship is maintained for the vast majority of the years. There's a couple of years where you have, a bit of a lag problem because you're acquiring the debt, and this formula through the beta is doing what you just pointed out. But there's nothing surprising about that. You're valuing a 40-year project. You have a couple of years where this relationship, is reversed for a few basis points. It's nothing surprising. As soon as you're in year two, what you have is, fully leveraged project with a cost of equity of 8.26%, far, far above the cost of debt.
And I'm actually just asking about year one. So the 6.48% levered cost of equity is lower than the 7.36% cost of debt, right?
In that particular year, yes, by 90 basis points, yes.
So
Please,
that
Mr. Delapiani, please wait.
I'll give my answer again. In that particular year, it is lower.
So your model violates the principle that Professor Damodaran endorses, right?
No, it doesn't violate the principle. The average cost of equity in our model is 7.42%. The average cost of debt in our model is in the low 7%. I don't have the number right in front of me, 7.1%, I think. And in fact, that's not even including the refinancing, which we were very conservative not to include at the market cost of debt. So no, the model doesn't actually, on first principles or on its dynamic, violate this principle. There's particular years in which this relationship is reversed. There's nothing concerning about that. You need to understand what this model is actually doing. And by the way, the year one of discounting, there's virtually no discounting. So it's actually the most irrelevant of all the years.
So you're masking your deviation from that principle in averages. Is that what you're saying, Mr. Delapiani?
No, I don't think you need to accuse me of masking it. I'm being very transparent about it.
I'm just trying to be intellectually honest, as you would say, Mr. Delapiani.
Can you both please observe again the 5-second rule?
I know, Mr. Delapiani, you wanted to take a look at what Professor Damodaran said. So I'll ask my colleague, Mr. Alvarez, to pull the spreadsheet off the screen and let Mr. Delapiani take a look. For the record, this will be Versant Partners Exhibit 3, Damodaran Applied Corporate Finance, 3rd edition, page 72. You'll see there, Mr. Delapiani, a question in box 4.9, cost of debt and equity. Can the cost of equity ever be lower than the cost of debt for any firm at any stage in its life cycle? Oops, and can you scroll down to the answer, please? And there's the answer to this pop quiz. No. Equity investors are always behind lenders and aligned for cash flows on an annual basis and for assets on liquidation. They should therefore demand a higher return. Mr. Delapiani, doesn't your model violate this rule?
No, it doesn't. It doesn't. As I said, on first principles and on the effect, because of what I just explained. And if you look at how the discounting operates, it doesn't violate this rule. And as I said before, and by the way, earlier you read this to me without saying, at any stage. The Damodaran is very clear about the stages of development of a company. You probably forgot to mention that part. Now we're in complete agreement with Mr. Damodaran about this.
The answer here, and I'll just read the question again, which I read verbatim in my prior questioning to you, Mr. Delapiani, and I invite you to check the transcript. The question is, can the cost of equity ever be lower than the cost of debt for a firm at any stage in its life cycle? Did you see that?
I do.
Thank you. All right, we can take that down. Thank you to my colleagues. In your report, Mr. Delapiani, you point to the Interject's offer of February 2017 as evidence of the fair market value of claimant's investment, right?
I do, but are you referring to a particular report? We have two.
That answer will suffice. To assess the project, Interject's developed its own financial model, right?
That's my understanding. There is a so-called Interject model, yes, which I believe was developed. Oh, go ahead.
Do you have any reason to doubt the authenticity of that model, Mr. Delapiani?
No, but I do have certain issues with the model itself, several issues with the model itself, which...
I'm sure your counsel can take you there.
No, hold on a second, Ms. Endicott. I'm pointing out something. You said authenticity, and I'm just building on that. I'm saying I don't have a problem with authenticity in the sense that I don't think anyone is, I have no reason to believe anyone has misrepresented the origin or provenance of this model. But there is a problem with the model itself. I invite you to open it up right now and try to use it and see what happens. I'm sure you've tried because you've done Excel. And if you open that model, what you will find is that it requires a password. It's password protected. It cannot be run. It has macros that have been blocked, and we have not been able to obtain the passwords to those macros or to unblock them. So if you want to talk about the Interject model, I have to tell you that there's several serious issues with anything that we talk about when it comes to the Interject model.
Are you aware that the Interject model was introduced into the record by claimants?
I believe we introduced it into the record. Was it claimants or was it us?
Well, it's in there, I think, more than once, both as Exhibit C47 and as BRG 0040.
That's what I thought. Yeah, we introduced it.
And are you aware that claimants introduced the model into the record as password protected?
My understanding is there is no other version. I tried to solve that, and there is no other version.
And have you been able to open the model on your computer? Open the document.
I've been able to open it with limited use, because the model, as soon as you try to enable its functioning, blocks and shuts down, literally closes. So it's very limited what one can do with it and understand its formulas. There's some things that one can do. I'm not rejecting that, but there are several limitations which I was pointing out before.
And this is the first time you've raised the absence of a password to the model as an issue to your ability to assess its inputs, right?
I don't know if I've raised this before. I've done with the model what I could do with the model, and I'm not trying to pull from the model what doesn't need to be pulled from the model, especially when Interject has a document from days before the valuation date that tells us exactly how much they're valuing this project at. And the model itself is of very little use compared to a piece of paper that says, here's an offer, here's how much we want to pay for this project.
The model applied an 8% cost of equity, right?
No, absolutely not.
Can we go to C47, VRG 40, sheet inputs, row 95, column C, please.
Exactly. Thank you for pointing it on screen. The discount rate is 8%. It's not a cost of equity. And that's why I made the distinction earlier that we have to be very careful. What is a discount rate? What is a hurdle rate? What is a cost of equity? What is a minimum required return? What is an IRR? And so on and so forth. Very careful.
So you draw a distinction between the discount rate and the hurdle rate, right?
That's exactly what we explained in our report, yes.
Okay. But in your report, you actually refer to this rate as a hurdle rate. And you state that in your second report, PDF page 72, paragraph 152. And actually you cite to Professors Burke and DiMarzo there for the explanation of a hurdle rate saying, quote, if the project can jump this hurdle, that is, have a positive net present value at this higher discount rate, then it should be undertaken. That is your quotation of BRG 94, J. Burke and P. DiMarzo, Corporate Finance, 4th edition, 2017, at page 848. So my question, Mr. Delapiani, is, in other words, for Interject, this was a minimum cost of equity that Interject would need to receive in order to invest in the project, right?
No, that we don't know that for sure, actually. We know that this is a rate that was put there as a hurdle rate. Again, the hurdle rate is a big word. It's a big catch-all for all these rates that investors use to say, well, how do we test this? But no, what you just said is not something that we can attest without asking Interject. What I can tell you are several things. One is that Interject itself looks at this project and says, whether it's in 2017 or in 2018, it looks at this project and says, if I pay out the existing owners, and because they're tired of putting money into this, they're tired of Peru, whatever reason, I don't know, they're in distress, they want to walk away, I'm not sure what they think, but they pay them off, and they need to put another 17 or 18 million dollars. Interject is all in for $25 million. So unless the model can generate net cash flows to equity holders in present value terms greater than $25 million, they're not going to go in. And we know they wanted to go in. So the logical inference is that they actually saw value above and beyond $25 million. The reason why this model may not reflect that is several. One is this rate, which we don't know its provenance. Two, the prices that it used are about half of the prices that were calculated by a sophisticated independent dispatch modeler. BA Energy Solutions. Interject just took a price and just leave it forward without actually doing a price analysis. There's several problems with this model. Not to mention, like I said before, we can't actually trace any of its formulas because when we open it, it falls apart.
You can't actually trace any of the formulas in the BAES electricity pricing either because they're hard-coded, aren't they, Mr. Delapiani?
Oh, that's because it's a product of a linear programming model. If you've ever done any electricity work, and I've done quite a bit of it, dispatch modelers produce their results in this way and produce a report or a document or an appendix that explains their assumptions, and assumptions which can be put into any other linear programming dispatch modeling software or program, or can be programmed from scratch, which is pretty tedious to do. But in the case of Peru, they can be given to COES or any of Peru's agencies to run and verify. So no, not at all fair comparison. The dispatch model that BA Energy Solutions provided is fully auditable and traceable by any engineer who has done one bit of dispatch modeling. Not at all the same.
Sounds like you're one of those engineers who's done a bit of dispatch modeling, Mr. Delapiani. Did you do that verification?
I am not an engineer, and I have never done dispatch modeling myself. I have used the product of dispatch modeling, and I've been involved in disputes in which the other side actually has used the results of the dispatch model equivalent to the one that I presented from BA Energy Solutions, come up with their own verification and said, hey, we don't like this input or that input. And we've had a back and forth between the dispatch modelers or between the experts who've used the assumptions and their products of those dispatch models. What I'm saying is there's a level of expertise and there's a level of transparency that I'm used to when it comes to discussing dispatch modeling.
So if you're not that kind of engineer, then did you have that verification performed by that kind of engineer?
No, BA Energy Solutions provided an independent, sophisticated, reputable study commissioned for purposes of a very specific question. They're reputable and they remain completely unchallenged. Your experts could actually have done that. I'm not supposed to do it for them. And by the way, when your experts point something out that we actually agreed with, we've modified it in our report. This is what this process is about. It's about finding the evidence for the tribunal to rely on. So no, I did not conduct an independent study of the BAS independent study. I didn't need to. I selected them. I know exactly. I selected that firm. I know how reputable and good they are at what they do.
And you had no way of verifying what they put in there because you would have had to be a specialized engineer in order to do so, right?
I verified it to the best of my ability, which is by discussing with them their assumptions, the assumptions that we gave them, the ones they came up on their own, the reliance on, which is almost, I think, 90% of their documents cited are all Peruvian public documents of the functioning of the electricity sector. there's absolutely no black boxiness in that model as there is with this. Anyone who actually has that level of skill can actually verify the BAS, BA Energy Solutions model.
And did you document anywhere in your report the assumptions that you discussed with BAES?
I think it's clear in their report which ones overlap with ours. There's a couple of macroeconomic assumptions about inflation, US inflation, maybe foreign exchange. The rest, basically their exercise consists of determining, given the grid of the matrix of power producers in Peru, from renewable to thermal into natural gas and into liquid fuels, what would be the supply-demand balance, and therefore the merit order in which each of these units would dispatch. And on that basis, the marginal price of fuels would determine the spot price. That's basically the general principle of dispatch modeling that BAES and anyone else would have followed. So I understand quite well what they did. I understand the data they relied on. In fact, I was involved recently in another arbitration where that was the sole and principal focus involving your same client. And dispatch modelers were brought from the Peru side as well to actually counter and have a discussion between them as to the right assumptions, et cetera. In that case, I should say it wasn't BA Energy Solutions that participated, but anyway, as far as I should go on that.
You mentioned that you felt like the Interject's financial model was a black box and you would have had to ask Interjects to understand some of those inputs, right?
I didn't talk about feeling anything about this. I can tell you I observed that this model could not be auditable or traceable.
And you mentioned that you would have to ask Interjects to get more information to do that, correct?
I believe Interject was asked. I certainly asked Latam Hydro reps, and they, I think, weren't able to get that. I think Interject itself couldn't actually find, they said that there was some expiration and these models kind of expired. That's my recollection and understanding, but you should ask Mr. Seelan or Mr. Jacobson or maybe counsel, because they're the ones who brokered that relationship. I didn't talk to Interject myself.
You could have asked claimants about the process for creating this model too, right?
I believe we did. I believe they were involved and provided a lot of the, or at least some of the inputs. I'm sure Mr. Seelan was involved in this. Pretty sure he was.
And are you aware that agreement to this financial model was one of the terms of Interject?
Perdón que los interrumpa, soy el estenotipista en español. No solamente les pido que dejen una pequeña pausa, sino también que hablen un poco más despacio porque realmente es muy difícil seguir la interpretación. Gracias.
Bueno. Agreement to this financial model was one of the terms of Interject's offer, right?
I don't recall.
Ms. Endicott, I'm sorry. You were talking while the interpreter was speaking, and I'm not sure if you heard him.
Ms. Carlisle, I heard him in Spanish, and then when I heard his Spanish stop, I waited and asked my question.
Okay, I'm sorry, but it didn't look like you could hear him, and I wanted to be sure you did hear what he said. Thank you.
No problem. Thank you for what you guys are all doing. I'll ask again. Agreement to this financial model was one of the terms of Interject's offer, right?
You'd have to remind me and point me to this financial model being what was being sought to be agreed on. I don't know if they were agreeing to this financial model, as you said, or to a financial model.
Are you aware of any other financial model generated by Interjects and claimants?
You mean an Excel spreadsheet? A financial model can be the terms of the revenues, costs, and their allocation between the parties. It could be a waterfall chart that simply says how we're going to distribute the earnings when there are any. To say that the language, that's why I'm asking you if you can put a document in front of me that says that they're referring to this Excel spreadsheet that we have on screen or had on screen, we can talk about it. But I've seen some transactions where the parties have agreed to a spreadsheet capturing their intents and expectations, but no, I don't think I could say that they were trying to agree to this financial model or a financial model in this sense. I don't know about that.
So just to clarify, Mr. Delapiani, you're not aware of any other financial model put together between the parties, Interjects and claimants, right?
You mean an Excel spreadsheet? I haven't seen others. If you mean a financial model, each of the offers is a financial model. And I'm not trying to be, cute with the language here. I'm really being precise, because the idea of a financial model to be agreed on a deal document, and that being an Excel spreadsheet, I've worked with deal lawyers for many years, and I can tell you they generally would not approve of an Excel being a prerequisite for a closing.
You're aware that Mr. Jacobson, in his witness statement, refers to this exhibit C47 as Interject's financial model for the Mamacocha project at footnote 29 of his first statement.
I'll take your word. I don't remember Jacobson's witness statement by heart. That's what I've been calling it, the Interject's financial model.
And claimants have asserted that they were going to accept Interject's offer, right?
The offer in which their
2017 offer. Excuse me. Let me try again for our transcript. And claimants have asserted that they were going to accept Interject's February 2017 offer, right?
That's my understanding. They intended to.
And can you point me to any indication in the record that claimants objected to this financial model before their scheduled financial close on 15th May 2017?
I have no reason to believe that they have objected to it. I believe that at that time, they probably had access to it and understood what it did and what it didn't do, something we don't have the luxury of right now. But what I can tell you, but I will sound like a broken record, is that the terms of that offer provide for a very, very obvious and clear indication of the implied value for all the equity in the project.
If we use your 14th March 2017 valuation date and apply the 8% discount rate we see in the Interject's financial model to the cash flow valuation generated, we see that the valuation in accordance with that model is 7.23 million, right?
Your question was, if we use your valuation date, apply the 8%, we see in the Interject model to the cash flow valuation generated. That's what Versailles does in their alleged benchmarking. They take one of the numbers, one of the strips, one of the series of numbers from the Interject's financial model, and they discount it at 8%. Is that what you're referring to?
Do you disagree that if you take those cash flows in the Interject's model and you apply the 8% discount rate, the value that is generated as of 14th March 2017 is $7.23 million, Mr. Delapiani?
No, and that's exactly why the model cannot be relied on, precisely because I don't disagree with that. Because if I disagree with that, I would be bringing up a host of other issues. But because I agree with that, I know that Interjects can't possibly, in their sane mind, be looking at the 100% value of the equity in the project as $7 million, when this equity in the project at that time was going to be 70% and would cost them $18 million to put in literally the year after. So why in the world would they go in to put $18 million into a project that has only a $7 million NPV for 100% of the business. By the way, the $18 million is their commitment, 100% their commitment. But the $7 million, according to Versailles, is for 100% of the equity. So it's even
So
worse.
I believe, Mr. Delapiani, your
It's even
answer to my
worse.
question was no.
Okay, could you avoid overlap, please?
Please, Mr. Delapiani, I don't think you have heard the interpreters that asked you to slow down. I don't want to be rude. I'm sorry, Mr. President, but he's not slowing down at all. I know it's very hard for the Spanish reporter.
I apologize. I did hear it, him, and I really apologize. Perhaps I find this a little too exciting.
Can you slow down to 50% of your usual speed?
Mr. President, if I may, I think throughout this proceeding, experts have given, and witnesses generally have been given a lot of leeway to explain their answers. And I think Mr. Delapiani was still explaining his answer with information that was relevant to the question posed by Ms. Endicott. So I would ask that he be allowed to finish his answers while he's giving them.
Mr. Delapiani, have you finished your answer?
Just very briefly, Mr. President, thank you. Just very briefly to round up the point. It cannot be logical, sensible conclusion to the review, the alleged review of the Interject, the so-called Interject financial model, to conclude that a model or a set of cash flows that produces a present value at whatever discount rate of $7 million for 100% of the project is commensurate, consistent, and logical when that same company needs to deploy almost immediately at least $18 million in capex of their own money. So what that tells you, by call it reverse engineering or just logical induction, that it cannot be that that model reflects the thinking of Interject at that time. Because if Interject was thinking at the time that the project's net present value for 100% of the equity is $7 million, they wouldn't even be talking to Mr. Seeland, Mr. Jacobson, or to any of this. They wouldn't appear in this record because they need to commit to $18 million literally a year later or less. So we need to understand these facts. We need to look at this record intelligently and say, what is Interject's thinking here? Well, definitely they're not thinking this thing is worth $7 million because just on their own, they're going to put 18.
Yeah, wait a moment, Mr. Delapiani. May I ask you here a question?
Of course.
And Ms. Endicott, if you allow me. The 18 million that could have been provided by way of equity, it could also be provided by debt, isn't it?
No, thank you for your question. The 18 is actually net in equity above and beyond the debt financing.
All right, but wait a moment. So the 18 plus the 7 is 25. That would all be equity. And then how much? What is then the debt? Would then be?
Oh, hold on. Just to be clear.
Mr. Delapiani?
Sorry. To be clear, the 7 at that time in the early 2017 discussions, the $7 million is not a cash injection by Interject. At that point, they're recognizing $7.6 million that claimants had already put as part of what claimants had already put into the project. What Interject commits to do as of March 2017 is to put an additional $18 million in capex of their own equity. Okay. It's the 2018 offers that change the dynamic a little bit. And that at that point, they want to buy them out and put the $18 million. So one way or the other, you always end up with the inference, the logical inference that Interject is looking at this project and saying, it cannot be that it produces $1 less than about $25 million, because then why bother?
But help me, was that the situation on 14 March 2017?
In 14 March 2017, my understanding was that Interject was looking to acquire only 70%. So they're 18 or so, $17.8 million. When you consider that to be 70%, the 100% equivalent of that equates to $26.9 million, $26 million. So generally speaking, we're looking at the same ballpark of numbers. They make perfect sense from Interject's standpoint. All that happens is that Interject in 2018 changes the structure of the deal, and instead of being 70-30, says, I'll buy you guys out because I know you're having trouble there and you want out. But that's a different dynamic in 2018, but the underlying numbers are the same. And that also makes a lot of sense, Mr. President, because it just turns out that those deals in 2018 are contingent upon Peru meeting certain conditions and making their life just as good or reasonable as the but-for scenario that we're considering. So in fact, the fact that those numbers coincide with the 2017 numbers makes perfect sense, because in both situations, the buyer, Interject or Glenfarne, is looking at the same types of but-for conditions. In our world, they're called but-for. In their world, they're called guarantees and commitments, or contingent deals contingent upon Peru restoring certain things and so on. We can pull up the offers and take their language, but that's basically the idea, is that the 2018 offers are contingent upon Peru restoring certain guarantees.
Thank you. Ms. Endicott, please continue.
Thank you. Interject's analysis in 2017 also included an assessment of the amount spent by claimants, right, Mr. Delapiani?
Sorry. Interject's analysis, you said? Sorry, can you repeat the question?
Interject's analysis in 2017 also included an assessment of the amount spent by claimants, right?
I assume they analyzed it. I don't remember seeing their work papers, but I know that claimants submitted to them what they had spent on, and Interject said, well, how about we recognize some amount of that as your 30% contribution. So I assume there must have been an analysis. I can't say I've seen a document. If I did, I apologize for forgetting what it is, but I don't know that I've seen a document that shows that analysis from the bottom up.
In fact, at footnote 122 of your first report, you note that Interject recognized sunk costs of 7.63 million, right?
Yes, that's what I referred to before. What I was clarifying is that I don't know that I've seen their actual analysis. I don't think we've been privy to it.
We see this recognition of 7.63 million in sunk costs in BRG 0041 with the sheet budget comparison in cell H16, which I'll ask Mr. Alvarez to please put on the screen. It's tab budget comparison. So different tab.
Let me have one moment, please, to reacquaint myself with this document.
And if you could zoom in, please, Mr. Alvarez, at least for me, it's a little hard to see. Thank you. And please let me know, Mr. Delapiani, if Mr. Cardani is better placed to answer this question.
No, I'm just looking for, I apologize, I really didn't remember that we had seen the source for the 763. I do apologize. It's been.
All right. No, I would like to ask you a question about this document. This value, the 7.63 million here, is what you refer to as the investment value of claimant's investment, right?
No.
I'll take you to, again, to footnote 122 at paragraph 61 of BRG1. And Mr. Alvarez, to make it easier on Mr. Delapiani, if you could just highlight the sentence that starts "in particular," which is about midway through the paragraph in the footnote.
I see. Investment value.
Could you, excuse me.
In that context.
Excuse me. Could you read for me the sentence that begins "in particular" and then just stop at the end of the sentence?
In particular, Interject recognized US dollars 7.63 million in claimants, quote, investment value, and close quote.
Thank you.
That's precisely what I was trying to clarify, is that this was not our calculation of investment value, which we've been referring to this morning. This is the equivalent in the Interject speak. Pardon me if I wasn't clear about that.
This is the investment value that Interject was recognizing in connection with its February 2017 offer, correct?
Correct.
Okay. So I'd like to take a moment to just add some of these values we've been talking about through our demonstrative. So if the tribunal will permit me a moment on our time, of course, to just pull that up. So, Mr. Delapiani, I believe you testified earlier that the investment value recognized by Interject was 7.63 million. Do you see that there?
Yes.
Okay.
I see it in a highly distorted graph that begins at 7. Something we are loath to always do is start graphs at but it would look even closer if you started at 0. So please go ahead, just with that note.
Sure. Okay. Now, you note that any comparison, and I'll take that down for the time being. Also, just as a procedural matter, Mr. President, I'm going to move on to my next set of questions, but I note that we're also very close to the scheduled time for lunch. I do intend to continue with Senores Cardani and Delapiani after lunch, given all the time we have in the schedule. So would you prefer that we break now or that we continue for 6 minutes?
Okay, how many more minutes do you estimate you're across the last?
I'm loath to say this, Mr. President, but it really depends on the length of the answers that I receive from those under cross-examination. I certainly believe that I can finish within the day.
What do you mean by within the day?
Our allocated time for the day.
Within the 90 minutes?
Yes.
Okay, so let's ask Anna, how many minutes has been spent on cross?
So far, the respondent has used about 1 hour and 48 minutes in cross-examination.
Well, that's 6, so there's still 50 minutes to go, I understand. How many minutes are left under the estimate?
About 42 minutes to go.
Representative, could you be mindful of the estimate? I know estimates are estimates, but could you be have another look at your questions? That
Yes, I will certainly be mindful of my questions, but again, can't make any promises about the answers.
I understand, but okay, we all have to work towards getting an efficient hearing. Good.
Of course.
45 minutes break until.
Mr. President, before we break, may I ask a question on a point of order? Of course, with no intent whatsoever to rush Ms. Endicott, I believe that our redirect will be very brief. And to the extent that that respondents would be prepared to go forward, we would be happy to go forward. And we're prepared to go forward with Versant in the afternoon, if that's in the interests of the tribunal and again, and respondents for the sake of efficiency. If not, we understand, we're also perfectly happy to proceed with the schedule, but we are prepared to move forward like that if that's an option.
Thank you for indication, Mrs. Zabalos, but I think Ms. Endicott is still, you want to use your 40 minutes or so, Ms. Endicott?
Yes, I intend to continue after lunch. And as I said, I'll try to stay within my limit, but I don't think it would be appropriate in light of the schedule to push Versant up unnecessarily today.
No, we don't want to push you, don't worry. So take first your time to have a lunch. And then we meet again at 18:10 CET.
Thank you.
Right?
Thank you, Mr. President.
Looks everybody is back. All right. Oh no, sorry. I see Mr. Cardani is not yet there. I think you're on mute, Mr. Delapiani.
Thank you, Mr. President. Mr. Cardani should be here any second, but we can proceed if.
No.
Thank you.
We wait for him. You all set, Mr. Delapiani and Mr. Cardani?
Yes, sir.
Yes.
Ms. Endicott, please continue.
Thank you, Mr. President. Hello, Mr. Delapiani and Mr. Cardani. Hope you got some lunch.
We were fed. Thank you. Yes.
Thank you.
So, Mr. Delapiani, you note that in looking at the 2017 offer from Interject, any comparison of the value of claimant shares implied by Interject's February 2017 offer you note that any comparison of the value of claimant shares implied by Interject's February 2017 offer to the value of those shares derived from a DCF analysis, quote, must assume that the Interject's offer would have been executed, right?
The comparison of the valuation assigned by Interject is relevant to the point where if one understands that transaction, that offer to be a bona fide, real document, a real offer that can proceed. That's what I mean by that.
So let me just, maybe to help keep your answers a little shorter, I'll just take you to the language in your report. That's BRG2, PDF page 69, paragraph 145, if you could, Mr. Alvarez, please.
Yeah.
And just to confirm that you state any analysis attempting to utilize, any analysis attempting to utilize the Interject's offer as a comparison to a DCF analysis must assume that the Interject's offer would have been executed. Okay, thank you, Mr. Alvarez. I think you can take that down. The terms of the offer contemplated that Interject would invest $17.08 million in cash in the project in exchange for the issuance of new shares, right?
Sorry, did you say 0.08? I think it's 17.8, isn't it? Did I have the number wrong? But it's probably not material to your question, but just to clarify, 17.8, I think is my understanding of the number.
So let me just ask again with that clarification for the record. The terms of that offer contemplated that Interject would invest $17.8 million in the project in exchange for issuance of new shares, right?
Okay.
The issuance of those additional shares would give Interject a 70% stake in the company, right?
That's right.
This offer didn't include Interject paying claimants for the existing shares, right?
No, the offer is recognizing claimants' investment and then committing to an additional investment. That's how we know and how we can infer value, the value of the asset from that proposed transaction.
So if the offer went through, as you say, we must assume, claimants' existing shares end up getting diluted from 100% ownership in the company to just 30% ownership in the company, right?
The latter part of what you said is correct. The premise of your question is, just to clarify, completely irrelevant, right? Because the issue of assuming that the transaction goes through is the comment that we made in the report, pardon me, in response to something Versant doesn't says about what happens before and after the transaction, when in reality, the information contained in the transaction, in the offer, is the underlying value of the asset, which is exactly what Versant and us set out to do in theory. We both set out to do the same thing, which is to determine the underlying value of this business, given by the RER contract, the studies conducted to date, the possibilities of everything that we'll do in the future. So if we're actually both trying to do that, and we certainly are, and we're trying to determine that fair market value on the basis of the underlying business, then what do we glean from the Interject transaction is that there's an entity.
Mr. Delapiani, I must ask you to keep your answers to my questions. Your counsel already said he'll do redirect, and you'll have a time to give these long explanations that you want to give. But my question was not about what you and Versant are agreeing on or how you interpret the intrinsic value of the offer. It was much simpler. And if you've forgotten it, I'm happy to repeat it.
I did not forget your question.
I'm sorry, Mr. Del Piano, hold on one second. Mr. President, again, throughout this proceeding, provided that the response, the explanation is relevant to the question, and I understand that the response, the added response must be relevant to the question. I have no dispute with Ms. Endicott about that. But witnesses have been given broad leeway to explain their answers in this proceeding, and I would ask that if there's going to be an objection to the answer, that the objection be properly posed, but that otherwise Mr. Della Piane and Mr. Cardani be allowed to finish their answer without interruption.
I must say that Mr. Della Piane is pretty long in his answers. So, and I think that they can be reduced to the essence. And I would like to invite Mr. Della Piane to be economical in his answers.
Thank you, Mr. President. I will do my best. Let me just explain that the question that was put to me was not whether Latam Hydro would be diluted from 100% to 30%. The question that was put to me was, if we assume that the offer went through, we must assume ... And then the question came. And so the way the question was put to me, in fairness to precision of language, I must answer it with some length, because it's just not a question that requires a yes or no answer. And I apologize for being long, but I'm trying to be very clear with this tribunal that the assumption of the transaction going through or not going through is absolutely irrelevant to the purpose of determining inferring value from the terms of the offer. And I was just explaining why. And I will stop there. And if you have any questions about that are unclear from my presentation today, I can expand on that. But that's what I was trying to clarify. Thank you.
Mr. Della Piane, just to remind you, it's the language of your report that says, and I'll quote it again for you, any analysis attempting to utilize the Interject's offer as a comparison to a DCF analysis must assume that the Interject's offer would have been executed, BRG2, PDF page 69, paragraph 145. That you can take that down, thank you. If we assume, as you say, we must, that the Interject's offer goes through, then claimant's existing shares would be diluted from 100% to just 30% ownership of the company, right?
To make that conclusion, we don't need to assume that, but the answer is yes.
And you assert that the terms of the offer imply that assuming that Interject's made its $17.8 million investment, the value of the company would be around $25 million, right?
The $25 million implied value can be derived from two different ways. One, by looking at the recognition of what 30% buys you, or in other words, what $7.63 million would have bought claimants would have been 30%. So you don't need the 17.8. I'm answering your question. You don't need the 17.8 to take an inferred value from the Interject transaction. It just so happens that this transaction was designed in a way that recognized pari passu, so to speak, the 7.63 and the 17.8 in a manner that was 30-70. So it's not a coincidence, obviously, but it happens to, it is again, not a coincidence. It adds up perfectly that you can look at this transaction from the point of view of the 30% that is recognized and how much that was priced at, or the 17.8 that bought the 70% and how much that was priced at. They're priced, obviously, in a consistent manner because we're looking at the same transaction. So you can look at it both ways, through the lens of the 17.8 or the other.
So let's look at it through the lens that you have said we must assume, which is that Interject does make its 17.8 million investment. In your view, then the value of the company would be $25 million, assuming that's executed, right?
Now, in my view, the value of the company is independent, is the fair market value is independent of that transaction happening or not, as we explained this morning. The Interject's deal details need to be understood under the light of that transaction, assuming they close. It's standard language, but the inference from the deal details are independent on that happening or not, as I just explained.
But you have agreed, Mr. Delapiani, that after the transaction is executed, the claimant's share of that value is 30%. 30% of 25 million is around 7.6 million, right?
7.63, and that's actually not what we're quantifying. We're here quantifying, as of the date of valuation, the value of claimant's share in the project, which was 100%. And we're not worried about the identity of the holder of that right at that particular time. We're interested with the underlying value of the value of the underlying asset, as I explained today.
So you want to assess the value of the project as of March 14th, 2017. Am I understanding you right?
Yes.
Interjects and claimants had not executed the transaction by 14th March of 2017, right?
Correct.
In fact, claimant was still gathering documentation for Interjects' credit approval at that time, right?
I believe that's correct. And that doesn't prevent anyone from actually understanding that underlying value of that asset, because it's not dependent on the identity of the holder, and it's not dependent on anything that happens on the day by day particularly, but rather on the cash flows it can produce in the future. So that hasn't changed. Pardon me.
There is nothing in the record that suggests that the impugned measures prevented the offer from materializing before March 14th, 2017, is there?
That's a matter of fact and law. What exactly and in what way exactly the transaction or the data valuation anchors our assessment is a question for counsel.
In fact, claimants assert that in the absence of the measures, the impugned measures, the deal with Interjects would have been finalized by May 2017, right?
You say, in fact, I understand that kind of contradicts what you said before. I'm trying to follow here. Can you repeat the question or perhaps rephrase it?
Claimants assert that in the absence of the measures that were impugned, the deal with Interjects would have been finalized by at least May 2017, right?
I think they say that. It's, again, like I said this morning, neutral and irrelevant to our valuation, but I think that's correct.
So in the counterfactual scenario, claimants have received a term sheet. They're on track to complete their due diligence by May 2017, but Interjects hasn't executed the offer by March 2017, right?
No. The counterfactual scenario that is the basis for cash flow analysis is neutral and agnostic to any of these facts. Pardon me.
This means that by March 14, 2017, claimants have not received the 17.8 million cash injection from Interjects This means that claimants have not received by that date, March 14, 2017, the 17.8 million cash investment from Interjects or the $1.5 million development fee, right?
When you say this means, what do you mean?
Okay, I'll take you back.
Sure.
In the counterfactual scenario, which means when there are none of the impugned measures, in fact, they haven't even happened yet, claimants have a term sheet. They're on track to complete due diligence by May 2017, but Interjects hasn't executed the offer by March 14th, 2017. Right?
Yes, and all of that doesn't build up or is relevant to our fair market value assessment.
That's not what I'm asking you. The fact that Interjects has not executed the offer by March 14th, 2017 means that the claimants have not received the $17.8 million cash investment from Interjects or the $1.5 million development fee as of March 14th, 2017, right?
No, of course not.
Now, you criticize Shop and Sakara for suggesting that the value of the Mamacocha project before Interject's invested would be different than the value after Interject's invested, right?
Absolutely. They're absolutely wrong about this. And
in fact,
no, hold on. Do I get a short, brief snippet, and it's really difficult if I'm interrupted, to be honest. But I think I do get
up to the tribunal. But I would say no. You've answered my question. Now I'd like to ask you another one.
Okay, go ahead.
Oh, no, Ms. Endicott, let the expert witness finish his answer. Della Piana?
Yeah, I'm rereading the question. Yes, we do criticize Versant for saying that the value of the asset that is at stake here, the Mamacocha project, will be different under different ownership. We think that's a violation of the fair market value standard completely. And that's just the beginning of it, but I'll stop there.
Mr. Della Piana, may I ask you a question here? Ms. Endicott, may I ask a question? Yeah. So let me help, if you can help me. So on 14 March 2017, the claimants have invested something like 7.3 or 7.4 million.
At that point, they've invested about 12 million.
12 million, okay.
Almost 8 of which is recognized, so to speak, in this deal that is going on.
So, so the value of that investment is to be based on what, according to you? If it would have been taken away, the investment, let's just assume that for a second.
Mm-hmm.
What's then? How do you value then that? Because that's 100% shareholding. Basically, you have capitalized the 12 million, if I understand it correctly. So how do you evaluate? Because what you, if I follow your reasoning, that you have to value it as a whole enterprise, then somebody who buys it at the time, and the third party bystander, how much would he or she pay for it?
Well, we know exactly how much he or she would pay for it because we know how much in cash flows the asset can produce, right? We test that through the discrete cash flow model. I'm getting there.
Let me say that I have been over that.
Yeah.
But that supposes that the remainder investment, the money which cost for what you need for the remainder of the investment, should come from somewhere. So if you do it in your modeling as a debt, so you can debt leverage. So you have then the 30% debt levering, if I can do that. Then you have to take into account for your whole model for the debt and the servicing of the debt.
Correct.
So then you get a different model. But if you do it by the way of a capital injection, somebody else is going to participate. Then in the remainder of the period, the investor has only 30% left. So it may well be that you can value that whole enterprise at a certain point at 100, but the investor will get only 30 back, isn't it?
Well, there's two parts to your answers to your question. It's a two-part answer. On the one hand, I believe, and it's been my understanding in most of these cases that I work on, in these types of expropriation cases and so on, that the fair market value standard should apply independently of the identity of the holder at the time, not independently of things such as the debt financing, but the equity that is held by the party that has rights to that asset should actually be entitled to that equity. I think what you're asking is, what if that party happens to be reliant on a third party? Is he or she supposed to share those proceeds or not, or obtain those proceeds or not? And in this case, what my colleague tried to explain this morning in cross-examination was that actually there is evidence of both the ability and intent of claimants to actually fund this purchase themselves. So to me, you can look at this from two different angles. One is, well, it shouldn't matter because what's been taken is 100% of the equity, not 30% of the equity. And second of all, even if you're concerned with any issue about how they would have potentially funded this, whether Interject would have closed in time, not closed in time, that should be relevant because of the fair market value standard, but also because the claimant committed to telling, I believe, DEG, that they would actually fund this themselves if that was what was needed.
All right, but okay, but then you talk about funding itself either via equity or via debt.
Mm-hmm.
At that point in time, on 14 March 2017, that just had not happened yet. So basically, what we're adding something hypothetical, isn't it?
Oh no, we are understanding this to be a situation in which we need to value this independently of who the claimant is or what the claimants exactly want to do with this asset, because they hold rights to 100% of it. And at that time, what we know is that the entities taking a look at this asset all agree, Interject, then Glenfarne in 2018, Interject again in 2018, our analysis as well, for what it's worth, we all agree that this asset would produce cash flows of no less than $25 million, which means that equity value, again, net of a debt to be repaid, that equity value is what matters. It's not the capitalization that has been made up until that point that matters.
Let me ask you the question. So on 14 March 2017, would then a third party, informed third party, purchase that asset for the fully 100%, as you say? Your calculation 45 million?
No, it would purchase it for 25 million. Careful with the 45 includes the interest and other ancillary damages that happen as a result of the dispute. So we're talking about $25 million, and the $25 million, absolutely, yes, a third party would buy it for that amount. We know that because, in fact, in the following year, the offers added up to that amount. These offers were for...
But is it not the offer, is that one part is you pay the investor, and the other part is to be funded by the offerer himself?
Well, but that's exactly what the investor was going to do, right? The $17 million is a negative in the discounted cash flow model, so you cannot actually deduct it twice. The investor going in, whether it's a new one or an old one, would go in and have to capitalize the company with those $18 million. That is already being deducted in the DCF model. If you actually assume that the value of the asset is 25, which already has deducted the 18, and then you deduct another 18 from the 25, that is not the value of the asset. That is actually the value of the asset with twice the capex.
Let me be clear. So you say, well, okay, that the intention of the investor is to fund one way or the other, either in capital contribution or by debt, the remainder what is necessary to complete the asset. The same would happen, isn't it, if a buyer comes there on the 14th of March 2017, says, okay, I see that you have to pay to spend some more money on this. I will do that, but I pay you out now. So how much is that? Is that then still the 100% with the possibility that he would spend in the future, or is that simply the amount he has there at that point in time?
It would be the amount that they are willing to pay would have to be commensurate with them still making a return. And what we see in the evidence is that if they pay $25 million, they're willing to pay $25 million to participate in this project. That means that they believe that the intrinsic value or the value that they can derive is even higher. So by...
Sorry? Okay.
Yeah, and this is all net of debt. I mean, I know you mentioned debt several times. In all cases, we're talking about the debt already being taken care of separately.
So on 14 March 2017, somebody comes along and says, okay, I'm prepared to pay 25 million.
Mm-hmm.
Would the entire 25 million go to the claimants, or is it that the part of the claimants have already invested and what the claimant had intended to add in the next year or so? That says, I assume that for myself. That's part of my 25 million. So to say, for example, it says, well, 7 million you have spent, that's what I think, and the rest I will pay later, either by my own financial. But that's the buyer who does that, isn't it?
They could structure this transaction in infinite different ways, but what we know is that the seller, and this is important about the fair market value paradigm, the seller wouldn't accept $1 less than the 25 or more that it can make by staying in the project and funding it itself. So the problem with this idea that a buyer can hold a gun to the other guy's head and say, well, how much do you really need for me to buy this thing? That's a problem because that doesn't consider that the seller is a sophisticated party which can self-fund this, can calculate the cash flows and say, I'm not going to sell for less than 25.
I see that. So, but when if they say, look, I want to stay on it, then you say, okay, you pay me my share, and so what actually was one of the proposals. They take 30%, and you take the 70%.
Yeah.
But if he says no, if we have to value the damage done on 14 March 2017, then one way or the other, it is 30%, isn't it?
No, the damage done to the claimant as of March 2017 is for 100% because that's what they owned at that date and what they were committing to develop and what is modeled in our cash flow.
Sorry, I expressed myself badly. So I mean, so in monetary terms, it's not the 25 million.
Why not, sir?
Because he has not yet spent 25 million on the project.
Wow, but that's the issue with value, sir, is that it's not backward looking. The value of a business depends on the cash that it can generate forward. This project could have actually, in all honesty, they could have spent $100 million digging the mountains of Peru like Swiss cheese, and that would not be relevant. What is relevant is what can this asset produce in terms of revenues minus costs in the future. That is the valuation paradigm that both Versant and us agree with. We shouldn't depart from that because otherwise we're just opening up to say that the value of this should be determined based on historical capitalization, which is not what neither Versant or us do.
So assume that he had only spent 1 million. Would he still be entitled 25?
If that's what these cash flows can produce, absolutely. But probably at that point, if it only spent 1 million, he wouldn't have feasibility studies, he wouldn't have hydrology studies, he wouldn't have the permitting, he wouldn't have a lot of things that make this project more advanced in the spectrum between an idea, greenfield, an advanced greenfield, pre-construction, construction, and an operational project. So the investments made get these projects in more advancement, as you see in mining cases, for example, towards advancement and operation. That's where the value evolves. In 4 years, once the construction is done and the project is pumping water through the tunnel and is generating electricity, the project value and the capex has been spent, the project value would be much, much higher. But is it dependent on the historical investment? It's not unrelated, but it's not the amount of the historical investment that determines that value.
Okay, I think I have the difficulties, but I understand the valuation approach. That's I can see that and how you have to evaluate it. But at that point in time, it was not yet complete, this project. That's my problem.
Yes, and that is accounted for in several ways. We have very high interest rates on the loan.
A little bit slower, please,
Sorry.
please.
Sorry. It's accounted for in several ways. There's all the capex that needs to be spent is being deducted from the value. The $25 million of net present value is after deducting all the capex contingencies, all the time delays, all the operating costs, all of that is being deducted, it's being removed. So we're not actually valuing this project as if it was in operation. And we know that because we are the ones actually putting in these contingencies in the model. We also know that we're actually loading up this project with very high rate of interest, as was pointed out today. And finally, we know this because in 2018, when Interject and Glenfarne come back and say, well, you seem to be having trouble, how about we just take this over? What they say is, well, a project like this, I'll pay you 8 and I'll have to put in another 18 and I still need to make money. What does that mean, Professor Vandenberg? What it means is that the buyer of the Greenfield project in the status that it was in 2018 or 17 recognize exactly what you're pointing out, that there's more value to be derived and that it won't pay the full amount of that value because if they do, there's no money to be made. If I think I'm going to buy a house for 100 and I'm going to sell it for 100 in 5 years, it's not a good business if I'm not going to live in it. But these buyers understood their business and they said 25 is what I'm willing to put, even though I have to run a business and make money and make returns on top of that 25. That's why we refer to this as a valuation that already considers and accounts for the status, the greenfield status, or the advanced greenfield, the pre-construction status.
Okay, thank you. Ms. Endicott, please continue.
There's just a second here. Professor Van den Berg, fellow members of the tribunal are having a small technical glitch. Mr. Delapiani, like Interjects, you also calculate an investment value for the project, right?
Yes.
And do let me know if these questions should go to Mr. Cardani since he presented on those calculations. But the investment value is also sometimes referred to as sunk costs, right?
Yes, my colleague will address this.
Mr. Cardani, the idea behind this value is that it looks at the costs spent and assumes that those costs contributed to the value of the project, right?
Well, I just would like to clarify that it's not defined as a sunk cost analysis. What we do in the investment value analysis is what we explained this morning. We look at the capital cost and capital investment, and then recognize a return on those investments commensurate with the return that the project that was terminated because of the respondents measure would have returned to that investor who put all those monies, which, by the way, just for the clarity of record, was $24 million.
Okay, so my question was, the idea behind this investment value is that it looks at the cost spent and assumes that those costs contributed value to the project, right?
As long as you don't use the word sunk cost, yes, these were investment for the development of the project, correct.
And Professor, well, that's okay. You calculate the sunk costs of the cost spent as around 19.09 million in BRG 81, right? And maybe, Mr. Alvarez, could you pull up BRG 0081, and then, if you don't mind, going to the control panel sheet, which I believe is the default open, and then we see there in row 11, total investment value 19.09, right? You with me, Mr. Cardani?
Yes, I'm with you.
And you mentioned that Mr. Sillen in reality found out that some of the company's costs were slightly higher earlier today. Is that right?
I think Mr. Sillen made a few adjustments, a few reconciliation in preparation for his second witness statement because of issues raised by Versailles, which are effectively factual matters. So this is this amount here that you see in row 9, column F, of $20.1 million reflects the total amount invested in the project. Then there are some adjustments, and the total investment value is 19.09.
And did you include any data from Mr. Sillen showing the work he went through to reconcile those additional expenses?
Well, I think that the very source of this is accounting record produced by Mr. Sillen. So all we did was to take these facts and accounted them into the determination of the total investment.
The costs here in this total, they're not limited to costs spent by the claimants themselves, right?
They are, I believe so. These are all costs or investments. Let's call them investments, not cost. These are capital investments to develop the Mamacocha project incurred for the Mamacocha project. The table is called investment value of Mamacocha project. It includes investment amounts for the Mamacocha project. That's what the exhibit says, and that's what it is.
Do you consider legal fees investment amounts that went to further the development of the Mamacocha project?
Okay, let me clarify that point for you. There were certain legal fees, I understand, certainly can be considered part of the development of a project, right? You need attorneys to get certain, permits and so on and so forth as a regular course of business. There were also ongoing legal expenses due to ongoing issues related to the measures at issue in this case that were incurred by the Mamacocha project and were unexpected. Therefore, for this very reason, they must be included into a total assessment on the investment value for developing the Mamacocha project. The Mamacocha project effectively incurred additional costs, legal costs due to the very measures. So when calculate damages, due to those specific measures, those costs must be taken into account. That goes into this calculation. It's only a portion, of course, only a small portion.
The expenses totaled here, they include expenses for 7 different investment vehicles in addition to the named claimants, right?
Where do you see that? Can you please tell me where?
Yeah, like Gray Invest, Latin America. You put the spreadsheet together, I assume you know. Maybe we can click over. But for example, Gray Invest Americas LLC included expenses there, right?
Yeah, there were different entities that were part of the legal structure that developed the project. But I think this is a matter of legal and factual matter. So I don't know if I'll be able to respond to any question as to
my question was just
which with respect to the correspondence of those entities with respect to claimants. I understand that these were all amount of money invested by companies related to Latam Hydro into the Mamacocha project. That's probably as far as I can go.
Now, these kinds of expenditures are sometimes considered by a potential buyer, right? We saw that with Interject.
Sometimes considered by a potential buyer. Well, I don't know if I would use the characterizing as sometime is appropriate. I think potential buyer make their consideration about how much a project can generate. Okay, that's the key aspect of calculating company value and make investment in corporations. So
and in a
I'm not sure what sometimes considered by potential buyer to would mean in the context of this.
Sure. So put differently, you would agree that in assessing the value of a company, a potential buyer may sometimes look at the investment into the development of the company made by the current owner, right?
I think it's a very broad and general statement. I think what a buyer looks at is the value generating ability of a project like the Mamacocha project. There was an ARB contract in place with sovereign guarantees with the government of Peru to generate to over $220 million in future cash flows, undiscounted. That's what they will look at. Then, of course, they will look at what is left potentially to develop or finished constructing that project, right? They would take into account the development stage of the project.
So
that's how how evaluation is performed by an investor.
Okay, let's take a look at one of those potential buyers who was Enfogen, a subsidiary of Glenfarne, and their November 29th, 2018 offer is in the record as Versant Partners Exhibit 48. And if I could ask Mr. Alvarez to please go to page 3 of the PDF. And scroll down a bit, please. A bit more. And a little further, please. Okay. Let me see if I can make this easier. Okay. And if you go down just a bit more, thanks. Okay. So we can see here at item 6 that the valuation assumptions are based on financial information provided by Latam Hydro, right?
Yes, I'm going to pick up now. Yes, I do. I see that.
Okay, great. And we see also that development expenses required to reach financial close, those will be borne by the seller. So here we can see that they are looking at those development expenses or investments necessary, right?
Sorry, I'm having trouble with the windows here. 1 second. Okay, can you go again, please? Sorry about that.
Yeah, just the basic point that here at item 3, they're also discussing development expenses required to reach financial close. So that again is a reference to the to funds that may be invested, right?
Well, it's a reference to the ongoing operation and who funds it until the transaction takes place.
But this potential buyer is also noting that the figures provided by Latam Hydro have not been independently verified by third-party advisors. And the proposed valuation is subject to change as a result of those findings. Do you see that there under pending due diligence?
Sure.
Okay. So in general, these types of investment costs, these development costs, are the kinds that would be verified by a third-party advisor when considered in a transaction, right?
I think they're referring to the forward-looking figures. If you scroll down, you'll see that you can scroll down a little bit. You don't want to scroll down. Okay, I'll read it to you.
I'm not in control of the screen. So.
Okay, point 7, projected O&M, SG&A, and major maintenance CapEx requirements in the materials provided by Latam Hydro are sufficient for normal operations. In other words, these are the kinds of things the buyer wants to know, is what is the projected cash flows, revenues and costs, both of them, and investments needed to be made. At that point, the expenses made to date are not particularly relevant to the buyer. The buyer is buying an asset they plan to operate. That is the real bread and butter of what they're buying. They're not buying easements, they're not buying feasibility studies alone. They're buying an asset that they plan to operate. So they want to know, what's it going to cost to operate this asset? And Latam Hydro has provided figures according to this, which they have not completed due diligence on.
I see that you've picked up this line of questions, Mr. Delapiani. So I'd like to take you also then, just for the sake of completeness, to the Interject's letter of intent, which is exhibit BRG 42. If we can scroll down to page 5 of the PDF, to item 5, development fees and development premiums. And we can see there that Interject is going to review documentation and invoices supporting LHL's past development costs, and subject to confirmatory due diligence as to the legitimacy of such costs, Interject will recognize such development fees as part of the LHL capital contribution. So again, we see here due diligence to determine the legitimacy of costs from the financial statements provided, right?
Well, in this case, because this transaction was premised on some amount of the transaction being premised on reimbursement of certain costs to date. So, or not reimbursement, pardon me, recognition of percentage ownership in relation to cost to date. So this transaction was structured a little differently.
And I think you noted in your opening and your remarks just a moment ago, Mr. Delapiani, that Interjects in fact only recognized 7.63 million of what you said was around 12 million in cost, right?
Approximately.
At paragraph 31A of your second report, you maintain that the use of claimants' accounting records are a reliable source of information for the investment values you calculated, right?
I'm looking for that specific wording. I think I would agree with that being a true statement. I don't find the exact wording, but I think that's fine. I agree that the claimant's accounting records are sufficiently reliable, but I also defer to my colleague's prior point that as a matter of factual record, we are not the ones who audited those numbers. It seems like our colleagues from Versailles had some issues with them, and Mr. Seelan responded to that in great detail.
The accounting records are on the record as Exhibit C 265, right?
I don't know, let's take a look. This is the 1,400 page tax returns and many other invoices and so on. Is that what you're referring to?
Is that Exhibit C 265?
Yes.
Yes. Have you reviewed all of that information?
We've taken a look, but it was not in our purview to audit or verify each of those costs. As I said, it's a matter of factual evidence whether those costs are appropriately conducted for the Mamacocha project. We have no reason to distrust that this set of costs as laid out were actually spent towards the development of the project.
To be clear, Mr. Delapiani, when you say it was not in your purview, you mean claimants asked you not to undertake that exercise?
No, that's not what I said.
Okay, so what do you mean by it was not in your purview? You just decided not to?
Well, as I said before, this is a matter of fact. It's not a matter of economics. We did not conduct evaluation and a detailed analysis of these because we're not the people who can actually go back and say, let's see, who is, let's pick one of these. Who else, I don't know, I gotta find invoice from a photocopy shop in Lima. Or did the lawyers really meant to charge that to the Latam Hydro account or to some other client? We did not conduct that analysis at that granularity. That's what I'm pointing out. It's a matter of fact. It's not a matter of expert evidence.
Your model includes about $5 million of cost from Gray Invest Americas LLC, right?
It's possible.
But there are no financial statements for Gray Invest Americas LLC for the years 2015 to 2021 contained in Exhibit C265, are there?
I couldn't tell you off the top of my head.
And I understand that for CHM, there were audited financial statements included, but just for the years 2013 to 2017, right?
I, once again, cannot tell you off the top of my head. I can point you to Mr. Seelan's very detailed reconciliation exercise, which remains unchallenged right now.
But you include expenses for CHM through 2020, despite the absence of audited financial statements, right?
We've been very transparent. We include everything that you are listing, everything that is on the spreadsheet, PRG 81, and we provided what we know to be a source and what we don't know to be a source. And like I said before, Mr. Seelan is the one who can actually answer these questions. He was the one who presented this evidence, this testimony, and he should be asked these questions.
Mr. President, I'm going to object, excuse me, I'm going to object because Mr. Seelan's testimony is that audited financial statements were produced. Mr. Seelan was on the witness stand. He was not cross-examined on any of these issues, even though respondents had every opportunity to do so. And they're putting questions about the factual record to our expert witnesses, which is entirely unfair. In addition, the issue of receipts was resolved in PO3 Annex B, item number 8, where the parties disputed as to whether receipts and that element of backup was required to be produced in this proceeding, and the tribunal ruled in claimant's favor that there was no need for it to be produced. And the summary reports that were produced and included would suffice. But in addition, the statement that audited financial statements have not been produced is incorrect.
May I respond briefly?
Yes, Ms. Endicott, please.
So my statement wasn't a global statement that no audited financial statements have been produced. It was limited to certain entities, and I invite you to review the transcript, Senor Ceballos. Also, the experts here who are testified that they relied on C265, and they found that information reliable. Now, if it's their expert opinion that the information contained in those records is reliable, I think it is well within the scope of cross-examination to ask them about the basis for that expert conclusion.
Okay.
But I'm happy to move on.
Ms. Endicott, please move on.
So, Mr. Cardani and Mr. Della Piana, you apply an update rate to these values that you claim were invested, right?
Yes.
Okay. And that update rate you explain is based on, quote, or excuse me, is intended, quote, to compensate claimants for the return they would have likely earned had they invested in a project similar to the Mama Cocha project without Peru's interference, right?
Ms. Endicott, you constantly read from my report. It would be so much easier and helpful if you tell me where you're reading from, and then I don't have to go back and check if you're actually mischaracterizing my testimony or not. If you just tell me, I'll read it and agree with you the first time.
Why don't you go to paragraph 17 of your first report?
Thank you so much. Once again, it's not distrust, it's a professional duty. Okay.
So you have explained that your update rate is based on or intended to compensate claimants for the return that they would have likely earned had they invested in a project similar to the Mama Cocha project without Peru's interference, correct?
That's the premise of the investment value calculation. That the idea is, well, what if what Peru did wrong here is simply that it shouldn't have enticed or invited this investment, and to put in a sort of rescission or argument or reliance argument, okay, well then return the funds, and what kind of a return would be commensurate with the risk profile of the investment that claimants went in? Well, they didn't go in to buy US Treasury bonds. They didn't go to buy Peru's sovereign debt. They went into a project in the renewable sector and the power sector in Peru. So from an economic standpoint, the only reasonable rate of compensation, the most reasonable rate of compensation would be one that actually is directly associated with the nature of the investment that was made. In this case, we use our cost of equity, which, as you point out, is much lower than Versailles.
But you agree that there are no comparable companies exclusively dedicated to the generation of electricity in hydropower plants in Peru, or countries with similar market characteristics and risk profile, don't you?
First of all, I'm not sure that we said that, but maybe that's an overstatement because there are some companies. But the most important thing is that you don't need to actually identify those companies. The whole idea of opportunity cost is, what am I missing out? What is the price of what I'm missing out for not being able to do one thing? If I buy lunch in this place, what am I missing out from having lunch in the place across the street? I'm not having two lunches. That's the idea of opportunity cost. In this case, the opportunity cost from an economic standpoint doesn't need to be associated with one particular investment opportunity or a particular company. And why? Because that would be a consequential damage. That would not be opportunity cost. Opportunity cost is the economic price for what we're giving up. That's what we quantify. The economic price for what's being given up.
What you're saying here, in essence, Mr. Delapiani, is that claimants should be awarded a return on that investment value as if they had invested in another project in Peru, right?
No, that's not what I said. What I said is that they should be rewarded for the fact that they went into this particular investment expecting a certain minimum return, the cost of capital, the cost of equity in this case, and that again is a minimum threshold. It's not the expected return. The expected return is substantially higher. So by using the cost of equity, we're recognizing the floor that would entice this investment, the floor, not the expected return.
So that's different than what you say at the paragraph 17 of your first report, which you just read, where you say it's intended to compensate claimant for the return they would have likely earned had they invested in a project similar to the Mamacocha project without Peru's interference. That aside, the return that you're talking about here is the return they would have earned on that project, right?
Correct.
And in order to earn that return, they would have had to undertake the risks associated with that project, right?
As in having committed capital between 2011 and 2022 now, that's exactly what risk taking is: to commit capital, develop an idea into a feasibility study, into further permits, auctions, lawyers, accountants, financial advisors, and so on. That is exactly what risk taking is. That's what they did, and that's what we would be calculating here is the remuneration associated with that. We would not be, to be very clear, calculating a reward or a return for the entirety of the project, for the full value of the project, just for the years that actually elapsed in which they weren't able to actually do anything, and their money has been parked in Peru.
So you're assuming that they would have earned the rate if they had been successful on another project, essentially.
No, I don't think you understood my explanation of opportunity cost. We don't need to assume that they would have. We need to understand what is the price for not having done so. That's a very different thing. Today we're having trouble, you and I, with these hypothetical constructs that are necessary to actually price things in economics. This is not they would have done this or they would have invested in Idrica or some of the other renewable projects. This is what is the price for them not having been able to.
Well, I'm not having any trouble, Mr. Delapiani, but I'm sorry that you are. Let's go back to some more just basic economic concepts. It was interesting because you were criticizing in your presentation today the pre-money, post-money distinction. And at page 22 of the transcript, line 8, at 8:27 this morning, California time, you were saying that actually in one of their papers, it's, as the literature says, for early stage companies that are comprised of little more than an entrepreneur with an idea. So that was your testimony about pre-money, post-money. But if we look at verse 25, we see that while it does state, and I'll ask my colleague to put it up on the screen for everybody's benefit, well, it does state that it may be used for early stage companies that are comprised of an entrepreneur with an idea. It also applies to pre-revenue companies, Series A stage companies, companies that have not yet developed revenue but have potential, which is where the Mamacocha project was as of March 14th, 2017, right?
I would absolutely object to the characterization of the Mamacocha project as comparable to a Series A company. Series A company not only is pre-revenue, has no proof of concept for the most part. The Mamacocha project has a PPA, a commitment for buying energy for 20 years that a financial institution will lean on to loan tens of millions of dollars. That is very different from a Series A company that is actually basically, let's see what it says here. Series A development, there's time to market, no validation, a very high risk and uncertainty, value maybe $3 million. We're looking at a renewable resource that is finite, that Peru needs at the time. It says it needs, at least it needed it for a while until it didn't anymore when prices went down. But we're looking at a finite renewable resource with conducted feasibility studies, technical studies made, capital commitments on almost at the door. You cannot compare that with a Series A company. And the RER contract itself is worth so much more certainty than any of this. Let's see what we're looking at here. Seed.
Are you finished?
No, not at all Series A company.
And you went on to say basically pre-money and post-money valuations are just used when you have two friends in a garage with an idea. And one of them put $100,000 in, the other one still hasn't. So the question is, if I put another $100,000 in. But you are aware, aren't you, Mr. Delapiani, that the pre-money, post-money value is also used by venture capital firms to value companies, not just two friends in a garage, right?
You said it yourself. This is not the land of venture capital. This is far from it. This is not even private equity. This is actually, proven concepts. This is feasibility studies. This is natural resources. You cannot
That wasn't my question, Mr. Delapiani.
Your question was whether
this method, you agree that this method is also used by venture capital funds, not just two friends in a garage.
I don't think, I think my illustration was very clear about what it intended to do. And absolutely, venture capitalists will consider this type of arrangement when they're looking at companies in their space, which is completely outside the realm of what we're valuing here.
Now, in your hypothetical about the two friends in a garage, you say it's the idea that if one of them put in $100,000 and the other one still hasn't, but he's thinking about it. Wouldn't you agree that a project with only $100,000 in cash is worth less than the same project after the friend invests another $100,000 in cash?
I'm so glad you asked this question, because maybe we can actually get to the bottom of it.
If you answer it.
If the project is unknown, has no certainty in revenue, no certainty in costs, and is just an idea, somebody says, let's create something new instead of pens with which people can write, but they have no idea how to implement it, where they're going to sell it, how many they're going to sell, who's going to buy them, are they going to have the proprietary know-how, et cetera, et cetera, et cetera. In your example, a company that has basically nothing but an idea, or maybe some advanced idea but no proven revenue, $100,000 may mean a lot, and making that 200 may mean a lot more. But for a company of these characteristics of the one we're looking at, that allows not just us, but also Interject and Glenfarne and Versailles and a bunch of institutions to actually conduct a cash flow analysis, to actually equate that to the example I gave this morning, or to venture capital, or to Series A or B, is completely misleading. No, in a company like the one we're valuing, $100,000 or the injection of capital is not what determines and drives the value of that company, because they actually is a process of de-risking. It's taking an idea to a natural resource commitment, or a PPA commitment in this case, and then developing that. We're not valuing this on the basis of the cash flows that it can produce once it's in operation. We're valuing this appropriately risked to the stage of development at which it was in 2017.
So is it your opinion that a willing buyer would pay the same amount for a company without $17.8 million in cash that it would pay for a company with $17.8 million in cash?
No, it would pay the same for a company that has to commit $17.8 million in cash to a company that has somebody who's ready to put the $17.8 million in cash. Because you see, they would value it on a cash flow basis, and the cash flow recognizes that $17.8 million as a reduction in value. So I have to change your hypothetical.
All right, so you can't answer my hypothetical, you want to change it, but I would just love it if you could answer my question, which is whether or not it's your opinion that a willing buyer of a company would pay the same amount for that company without $17.8 million in cash that it would pay for the company that had $17.8 million in cash.
Miss, first of all, you should appreciate that. I'm the one warning you that I'm, changing your hypothetical, to actually make it intelligible to the tribunal. In your example, the company that has more money may be worth more, maybe not. What matters is what is it that it will receive in revenue, and what is it that it needs to spend the money on. That's all that matters.
Okay, so I think you were saying that a company that has more cash on its balance sheet, all things being equal, is worth more.
Not necessarily. A lot of companies are penalized for having cash. Sorry, we're getting into a discussion that is actually totally unhelpful to the tribunal, but I'll answer your question. Companies that have a lot of cash are seen by financial analysts as being inefficient because they're not reinvesting that cash appropriately, or they're not paying dividends or buying back shares. So actually, if you really must know, holding cash is typically seen as a bad thing for companies.
So I think if we've gotten to the point where you feel like your testimony isn't useful to the tribunal, we can go ahead and end our cross-examination there. And I thank the tribunal for its patience and the court reporters as well. Thank you.
Thank you, Ms. Endicott. I look to Mr. Ceballos. Do you need time for preparing the redirect, or you can immediately go? Because you said that you have a few questions left.
I would like it if we could take a 15-minute break and then come back to the tribunal with my redirect, which will be very brief.
15 minutes recess.
Thank you.
Until 19:35 CET. All right, we all there? Mr. Ceballos, please proceed with the redirect.
Mr. President, before we get started, I was wondering if we could deal with one housekeeping issue.
Sure.
I noticed that the transcript has no record of my objection on relating to PO3. And that concerns me a little bit. Because
relating to what? Excuse me.
PO3, my last objection. And my only concern is I'd like to be sure that we don't have any issues with the transcript, or that that's something that can be corrected. I would imagine Ms. Endicott is also equally wants to make sure that the record is clear on this. So it'd be nice if we could sort that out before we proceed.
I think that can be sorted out on basis of the floor tape.
Mm-hmm. Okay.
Let's see what it is. If it means anything, it would surprise me, but anyway, let's see. Okay. Then please proceed.
Okay, thank you. If we could please put up paragraph 16 on page 4 and 5 of Mr. Jacobson's second witness statement.
Didn't ask any questions about Mr. Jacobson's second witness statement.
Okay, if you'll bear with me, I haven't asked any questions yet. I've just asked the exhibit to be put up. Mr. Cardani, you, in response to a question about the claimant's ability to self-fund the project, you referred to Mr. Jacobson's first witness statement. I'd ask you to just read Mr. Jacobson's second witness statement at paragraph 16 and let me know if this refreshes your recollection as to your basis for that statement.
Yes, give me just a moment, please. Yes, it does.
Okay, and this, can you tell me what this paragraph?
Just terms of getting objections on the record. Are the rules of redirect such that counsel can pull up an exhibit or document that wasn't referenced at all during cross-examination, show the witnesses exactly the paragraphs he wants them to read, and then proceed to ask a bunch of questions?
The second point is well taken. The other points depend on what was asked in cross-examination. Mr. Gonzalo, Mr. Ceballos, please, may I invite you not to be unreasonably leading?
Sure. Mr. President, I don't even need to ask any questions on this. I just wanted the record to be clear.
No, but that's not the purpose of a redirect. Record to be clear, you can do that during argument.
Very well. Mr. Della Piane, if we could turn to paragraph 145 of your second report. And Tom, if you could put that on the screen, I'd appreciate it. Now, Mr. Della Piane, could you take a minute to read the entire, well, let me start over again, in light of the last objection. You were asked repeatedly questions pertaining to the last sentence in this paragraph, which states, given that the only relevant but-for scenario is the one in which the Mamacocha project is developed, any analysis attempting to utilize the Interject's offer as a comparison to the DCF analysis must assume that the Interject's offer would have been executed. I would invite you to review the first sentence of this paragraph and any commentary that you would care to give on the compatibility of these two state sentences in this paragraph. I'm sorry, the first, yes, correct.
Thank you. Well, I thought I was clear about this, but perhaps it's more clear in writing than I was verbally. The analysis does not need to assume or presume the execution of a deal with Interjects because we're determining damages to the equity holdings of claimants as of March 14, 2017. And the fact that there's a proposed transaction, if anything, should provide valuable information and more confirmation of value and not more doubt and more opportunity to actually distort the value that existed at that time. The fact that we are set out not to do a contract claim or a commercial dispute, but a fair market valuation in a treaty case in which the right is for 100% of the equity holding. And that's the task that both Versant and I are tasked with, to determine the fair market value of 100% of the shares into the Mamacocha project. That means that that we conduct the analysis that we do, and that faced with an Interject's offer, we don't care if it was executed or not, because we're actually trying to determine what was the value of the underlying asset. We don't care if the buyer wanted to buy, if the seller wanted to sell. Those things are not relevant to a fair market value determination. I hope that clarifies things, but perhaps the writing is clearer than my words.
And Mr. Della Piane, who was the 100% equity shareholder of the Mamacocha project on the valuation date?
Latam Hydro.
Okay, I have no further questions.
Thank you, Mr. Ceballos. I look to my colleagues. Professor Tawil, any further questions?
No, Mr. Chairman, I have no questions. Thanks.
Professor Vinuesa?
No, thank you. I have no questions.
Okay, I have no questions either. Thank you, Mr. Cardani and Mr. Della Piane, for testifying, excused as an expert witness.
Thank you, Mr. President, Professor Tawil and Vinuesa.
Thank you.
I look to Mr. Ceballos. You're still the porte-parole for the claimants today.
Yes, I am.
I will designate you that way. And I see Mr. Granet also. So is there any point of procedure, householding admin that you would like to raise at this point?
Other than the issue I raised on the transcripts, no, Mr. President.
Gani?
Nothing, Mr. President, other than to thank you and the members of the tribunal for the questions that you have received, which we will, of course, address in our closing statements. So thank you for that. Very helpful.
Right. Okay. So it was not too early for you, Mr. Gani. That was our concern.
No, Mr. President, they're quite helpful. Thank you.
Right. Okay. So then you can all address them, hopefully in your closing statements on Friday. Have you made any progress on the post-hearing briefs?
We have not yet consulted amongst the parties, Mr. President. I think that, to be honest, Mr. President, we were waiting to see the questions. I think the questions and the extent to which we can address those questions in closing will be important in determining whether we believe that post-hearing submissions would be necessary or helpful. I think that in the light of the questions, it may not be necessary to have post-hearing submissions, but it's something that we still need to discuss with opposing side.
If I may make a suggestion, what would be helpful is that on the basis of the indexes of your written submissions, the alegatos, that you could make an index on the most important points of the transcript that you believe support those points in the table of contents. If you simply use the table of contents, you have pretty elaborated tables of contents, both sides, and then you could index the transcript there, but you would use the most important points, and not everything, but what you believe supports your case.
That is an excellent suggestion, Mr. President. And may I ask, is that something perhaps that could be submitted within a reasonable period of time after the hearing in lieu of the post-hearing submissions?
Exactly. That's a suggestion I have. But, and you may, for example, embellish it with a 10-pager, simply say, well, look, have you seen this? And this has not escaped your attention, undoubtedly. So this type of a 10-pager you would like to add.
That's an excellent idea, Mr. President. I'd be happy to take that on. Thank you.
Mr. Ceballos, maybe also you can reflect on this.
Yes, Mr. President, we're happy to engage in that exercise. And as to the issue of briefing, we're still consulting internally on that.
I'm sure I understand that, but it's maybe unusual, but in my experience, it's practical to have such actually an index on the transcript. Both sides find important, so that at least we don't miss anything, but what you find important.
Very well.
Okay. On that note, I look to my colleagues. Anything further?
Not from my side.
No.
Thank you. Then I see you all tomorrow.
Thank you, Mr. President, members of the tribunal.